Hello and welcome to the 2011 Ohio High School Mock Trial Championship. I'm Dan Schellenbarger from the Ohio Channel. We're coming to you from the beautiful and historic Ohio State House here in downtown Columbus. The room that we're in right now currently serves as a hearing room for the Ohio Senate, but it was originally the law library for the Supreme Court of Ohio and thereby an appropriate setting for this event. In 1901, the Supreme Court of Ohio heard cases in the room directly above us. Today, the third branch of government, Ohio's Supreme Court, has its own building, the Ohio Judicial Center, just a few blocks away from here. In just a few minutes from now, two teams of students from two different Ohio high schools will argue a case before a panel of judges for which they've been preparing since September, when the high school mock trial case was released at the Center's annual Law and Citizenship Conference. They've advanced through 3 different levels of competition to make it here today, and the winning team will advance to the national tournament, which will take place in Phoenix, Arizona. The Ohio Center for Law-Related Education coordinates these mock trials. More than 340 teams have been here, competing this year to get here. The 2010-2011 case is titled Taylor Henlacks versus Dr. Dana Brody. After an individual died suddenly, an autopsy was performed with the family's consent to determine the cause of death. During the course of this autopsy, it was discovered that the brain cells are regenerative or immortal. The descendant's family has filed a lawsuit against the county coroner, alleging that the coroner violated the family's due process rights by sending the regenerative cells to a research lab instead of returning them to the body. Our two teams here today are Olivia, Davidson, Washington, and Archbishop Hoban High School. Team Washington is from Athens County. The Athens homeschool program has existed for 7 years. The club consists of homeschoolers in the Athens area. Team Thomas is from Summit County and has participated in the high school mock trial program for 26 years. Team Thomas has won 2 state championships, one in 1994 and one in 2006, and won second place in the 2009 and third place in 2010. And joining me now is Addie Natalie of the Ohio Center for Law-Related Education, and she's the coordinator of the mock trial program. Addie, thank you for joining us.
Thank you so much.
Can you tell us a little bit about your center?
Well, the Ohio Center for Law-Related Education was originally started with the high school mock trial program 28 years ago. Ohio's high school mock trial program is the second largest program in the nation, only behind California, with nearly 4,000 students participating each and every year and 2,000 legal volunteers who make it all happen from around the state.
That's great, 28 years. So the center's older than I am. So what kind of things do the kids get out of participating with this program?
The students who participate in the mock trial program get experience public speaking. They get experience thinking on their feet. They also get to engage in writing practices while they do their openings and closings. They get experience being on a part of a team. There's also academic correlations as well. Ohio High School Mock Trial program is correlated to all of our academic standards for the high school level for English language arts and social studies. So there is a big learning component involved.
Now, I just said either 340 or 360?
Yes, you are right. 340 participated. We had 360 teams register, and through various reasons, sometimes they don't make it to competition. But our district competition was held on Friday, February 5th, with 340 teams around the state. Those teams that won both plaintiff and defense trials then advanced to the regional level. That was Friday, February 25th. 108 teams competed at that level, and then our state competition started on Thursday, March 10th, with 28 teams. Those teams who are here with us today won 2 trials on Thursday, 2 trials on Friday, and they're here at the final trial. So that's a total of 8 trials they've won to get here.
Wow. So are there a lot of repeat teams that end up here at the national, or at the statewide competition?
We do see teams that tend to come to the state competition more often than others, but Olivia, Davidson, Washington is one of our newest teams to the mock trial program, and each year we have about 30 or 40 new teams get involved every single year. So it is great to see so many new students get involved.
Now, the Olivia team is a homeschool team.
Yes.
Is this the first time that a homeschool team has made it this far?
It is the first time that we've had a homeschool team made it to even the state level, but the state final round. we're excited to have them here.
So now, how, if for people that are watching this, if they're interested in their own school getting involved with this, or their own homeschool group or whatever, how would they go about trying to get into the competition?
We'd love to have any group involved who's interested in participating in any school program, and they can reach me by email or phone at the Ohio Center for Law-Related Education.
Great. Well, thank you, Adelie.
Thank you so much, Dan.
Now we're going to talk a little bit about this year's judges. This year's presiding judge is Justice Robert R. Cupp. Prior to his election to the Supreme Court of Ohio in November 2006, Justice Cupp served on the Ohio Court of Appeals, 3rd Appellate District, which comprises 17 counties in northwest and west central Ohio. Before becoming a judge, Justice Cupp served 16 years as a member of the Ohio Senate, beginning in 1985 and ending in 2000, with the advent of Ohio legislative term limits. Before his election to the General Assembly, Justice Cupp served as a Lima City prosecutor and an assistant director of law from 1976 to 1980, and twice was elected Allen County Commissioner, serving from 1981 to 1984 and 2001 to 2002. Gary Daniels is originally from Youngstown, Ohio. He is the Associate Director of the ACLU of Ohio and heads the ACLU of Ohio Regional Office in Columbus, where he's lived since February of 2008. Mr. Daniels has worked for the ACLU for more than 10 years, from 1995 to 2000 and 2003 to the present. Before becoming Associate Director, he worked for the ACLU of Ohio in the position of Litigation Coordinator. Mr. Daniels currently serves on the boards of Ohio Center for Law-Related Education and Community Shares of Mid-Ohio, where he's also on that organization's governing committee. Judge Mike Fain was first elected to the District Court of Appeals in 1986. Judge Fain received his BA from Yale College in 1968 and his JD from the University of Pennsylvania Law School in 1972, with the American Jurisprudence Award in Constitutional Law and in International Law. Judge Fain was born in Miami, Florida, and has resided in several states while obtaining his education during his service in the United States Navy Reserve. Judge Fain entered the general practice of law in Dayton in 1973. He lives in Washington Township in Montgomery County. Jeff Ginsburg is a graduate of Walnut Hills High School, the University of Cincinnati, and the Vanderbilt University School of Law. He was a legal aid attorney for 6 years, a magistrate for 12 years, and now a lawyer in private practice in Millersburg, Ohio. Mr. Ginsburg serves on the Ohio Supreme Court's Advisory Committee on Domestic Violence and is the current chair of the Ohio High School Mock Trial Competition Committee. Judge Jerry McBride received his BA in Political Science from the University of Cincinnati in 1973 and his Master's of Public Administration from the University of Cincinnati in 1974. Mr. McBride currently serves as a judge for the Claremont County Common Pleas Court. He also previously served as a judge for the Municipal Court and as a county commissioner for Claremont County. Ohio State Bar Association President Carmen V. Roberto practices with the Akron law firm of Bernlohr, Niekamp, and Weisensell in the areas of criminal defense and civil litigation. He has represented OSBA District 11 on the Board of Governors, chaired the OSBA Ohio Lawyer Board of Editors, and has chaired the OSBA Membership Public and Media Relations and Publications Committee. He's also served on the OSBA Task Force on Gender Fairness and is a member of the Negligence Law and Traffic Law Committees. He was also a member of the Ohio State Bar Foundation Fellows Class of 2006. And finally, State Representative Lynn Slaby is currently serving his first term in the Ohio House of Representatives. He represents the 41st District, which includes parts of Summit County. Representative Slaby received his Juris Doctorate degree from the University of Akron, as well as his Bachelor of Science degree in Business Administration from the University of Akron. He recently retired from the 9th District Court of Appeals. Before his appointment and election there, he served 14 years as a Summit County prosecuting attorney. Well, those are our judges. Now we get to talk a little bit more about what we're going to see here today. To help us guide us through what we're going to be watching is Lisa Eshelman and Kurt Hunt, co-chairs of the 2011 Ohio High School Mock Trial Committee. Lisa is an attorney with the Ohio Environmental Review Appeals Commission, and Kurt is an attorney with Dinsmore and Scholl, LLP in Cincinnati. Thank you for joining us here today. Let's talk a little bit about this case. When we first saw it and we heard about brain cells regenerating and that they're immortal, we were wondering, is this a zombie bill of some sort?
This is actually it was inspired by the book The Immortal Life of Henrietta Lacks. So there's actually a root of fact in this case, and it's an interesting scenario because the cells that they discovered are regenerative. They just keep going, and the possibilities for treatments for different degenerative diseases are pretty stunning, honestly. So in real life, Henrietta Lacks never knew about the cells being taken, and that's mirrored in the case today, just sort of framing it in a more legal rather than historical way.
So this is a real case. This is based on a real case.
Yes, based on a true story, right.
Now, are a lot of the cases that the kids will argue, are they based on real cases?
The foundations, the case law foundations, are all based on U.S. Supreme Court decisions around the 14th Amendment and property right interest and what's the proper limitations of property interest. So yes, they are all based on U.S. Supreme Court cases.
Now, what do you think that the judges are looking for when they're actually when they're arguing the case?
At this level, the judges are looking for mastery of the rules of procedure, the rules of evidence, and most importantly, this case. They're looking at the lawyer's ability, the student's ability to go from recitation of the facts to applying the case law. They're looking to see how do the lawyers interact with the witnesses. Are they properly direct examinations? Are they proper cross-examinations? And are they raising the proper objections and responses to those objections?
Now, Lisa, you've been involved with this for a number of years. Can you talk about maybe some of the highlights you've seen in the past?
As I told the students last night at the semifinal rounds, I am amazed at the level of competition we see year after year. I told the students last night, if half the lawyers who appeared before me operated the way these students do, it would make my job immensely more fabulous. They're operating at a level of real trial lawyers, and that's the most rewarding part of the experience. And I'd send anyone in a courtroom, and I'm glad I'm retiring in about 9 years. By the time these kids get out of law school, I'll be on the downside, and I won't be competing against them.
Kurt, can you talk about like some of the advantages of getting involved with this program?
Oh, there's so many. I mean, it's interesting because this year in particular, I've heard a lot of stories from parents of students who have been involved saying, it was a hard year for their son or their daughter, and they'd never really found a specific program that worked for them. And then they get involved in the mock trial, and it's such an interesting combination of the intellectual and the competitive that you don't get to see very often. And so you have I think a different level of immersion in this kind of program. The students, especially at this level, the students are really into the program. I mean, they know the case inside and out and backwards and forwards, and they live and breathe this stuff for a few months. And I think it goes a long way toward demonstrating dedication and real, like Lisa said, mastery. I mean, you get to see the real outcome of mastering a particular case and a particular program. And whether or not they make it this far or not, I think the students get a lot out of seeing all of this come to fruition. You get to go up there and demonstrate that you understand this stuff and you know how it works. And when you're done, you really have a sense of accomplishment.
Now, a lot of us have a very superficial understanding of the legal process, of the court system. If we're lucky, it's because we've watched television and we've kind of seen those shows, how they gloss over the details. If we're unlucky, it might be because we've appeared in front of court somewhere, appeared in a court. How do the students begin to learn the actual process? Because what we're seeing is very similar to what an actual case would look like if it was being shown, done right in front of argued right in front of a judge.
Absolutely. One of the traditions for the mock trial program has been the students for each school are paired up with a practicing lawyer in their community, and that practicing lawyer serves as an advisor. So when the students get the problems, they're working directly with a real live actual trial lawyer who helps them understand the process, the rules, how you put a case together, how you develop a theory for each of your cases, and then they provide that that expertise along with their actual teachers in the classroom. So it's a combination of both inside and outside, and that's what makes it work. That's how the students understand that level of detail.
Kurt, how similar is this? Would this be to some legal training, actually going to law school and some of the trials that you would do in law school?
Honestly, I think it's better than a lot of legal training. I mean, it's difficult to get real practical training in the legal industry. It just tends to not be how we work. And this is really a chance to see the process. I mean, really from beginning to end. And you mentioned most people having a slight grasp on the legal process. I think by the end of this, these students have a very good grasp of it, and as good as they're going to until they start getting into law school, which presumably a good portion of them do.
I think they do. I think they absolutely do.
I'd be interested to see statistics on that, but I think it would be hard to walk away from something like this without a deeper interest in the law.
What kind of inherent traits or skills would a student have that would say, you know what, you might work out well having a career as a lawyer? And what you're watching for here, what kind of skills that you can see that would maybe be a natural type of disposition that one of the students might have?
I would say thoroughness above all, but Lisa?
I think attention to detail. Students who like getting up in front of people, who like the ability to performing, so to speak. Trials in many respects are like acting. Someone who likes the analytical aspects of the law, taking a set of facts that presented, researching what the law is, and then applying that. So students who are naturally inclined in those ways tend to find themselves drawn to the law. There's also the component of lawyers who get into the field because ultimately are there to help people. And so it's another way for individuals to serve.
And then just kind of going along with that same sort of idea, there's so many different aspects. Many lawyers don't actually end up in a courtroom. What type of lawyering would this help be training? If a student really is enjoying this, then they would want to go into what part of law?
Well, certainly trial is only one aspect. I can see lawyers who are engaged in business, transactional, when we're talking about the contracts and the sale of cells is one area. Technology, the medical field, when we think about what these cells can do for medicine, and that biotechnical is a booming field and area in study of law. So it's more broad than just trial lawyers. There's healthcare involved when you're talking about what are the right parameters for the medical field as a whole when we're talking about these incredible advances that are going on.
Well, great. Thank you both very much. I believe we get another chance to actually talk to you after when the judges are deliberating, so we'll get to a little bit more in the specifics of what's happening here today. But Lisa, Kurt, thank you very much for your time.
Thank you very much.
Have a good day.
And I think we're going to try to fit in one more interview real quick. Joining me now is Jared Reitz, Director of Programs for the Ohio Center for Law-Related Education, and he's going to talk a little bit about this center. How big is this center, as this program nationwide?
The Ohio Mock Trial Program is the second largest in the nation. Only California has more participants. In the state of Ohio, it started with 360 teams. And so it's the largest academic competition in Ohio, and only boys basketball has more participants. The Ohio Center for Law-Related Education is the largest state law and civic education provider in the nation. We're very proud of that.
That's great, and we just have a few more seconds here. We're going to get ready. So what if people were interested in getting involved in the program, what do they do to find out a little bit more information?
They can contact us. They can go to our website at www.oclre.org, and they'll find our programs there and contact information.
Great. Well, I can hear right now that I think we're about ready to get underway. You're watching the Ohio Channel, and we're going to be joining the Ohio High School Mock Trial Championship. It looks like the proceedings are going on right now. We'll go to the main floor of the courtroom. Thank you.
Please be seated. Good morning. My name is Bob Cupp, and I'm a Justice of the Supreme Court of Ohio. We have a distinguished panel of individuals who are judging this morning, distinguished in their occupations in the bench and the bar, and I'm going to ask them to introduce themselves, starting at the far left end.
Thank you, Your Honor. I'm Carmen Roberto. I'm president of the Ohio State Bar Association.
I'm Mike Fain. I'm a judge of the Ohio 2nd District Court of Appeals headquartered in Dayton, and I'm a member of the competition committee of this competition.
Jerry McBride. I'm a judge of the Claremont County Court of Common Pleas and also a member of the mock trial competition committee.
State Representative Lynn Slaby, 41st House District, retired from the 9th District Court of Appeals.
I'm Jeff Ginsburg. I'm an attorney in private practice in Holmes County and a member of the competition committee.
I'm Gary Daniels. I'm the Associate Director for the American Civil Liberties Union of Ohio and also sit on the Board of Directors for the Ohio Center for Law-Related Education.
Are counsel ready to proceed?
Yes, Your Honor. But before I begin, I'd like to take a moment to introduce my team. My name is Simeon Robe. I will be the opening attorney for the plaintiff today. My co-counsel is Sarah Welch. She will be the closing attorney for the plaintiff today. We will call two witnesses. First, we will call Dr. Parker Reese, played by Laura Markey. And second, we will call Taylor Henlacks, played by Christian Thomas.
Counsel for plaintiffs may proceed with opening statement.
Who owns your body? Does the state own your body? Does the coroner? Does County Coroner Dana Brody have the right to take and sell for personal gain the brain of a deceased young man? The evidence today will show that Dr. Brody did so unlawfully and should be held liable, therefore. Sean Henlacks, the younger brother of Taylor Henlacks, was an 18-year-old senior in high school. Sean contributed to society by volunteering at local charities and other social events. He expressed his beliefs to his older brother, Taylor, that when he died, he did not want his organs harvested, but wanted to be buried whole to give his friends closure. Tragically, Sean died 3 years ago in a single-car accident, and his body was taken to the Buckeye County Coroner for an autopsy. During this autopsy, Dr. Brody, the coroner, had a section of Sean's brain removed and tested by Dr. Reese in the pathology lab. While testing Sean's cells, Dr. Reese stumbled upon a surprising discovery. Sean's brain cells were alive and reproducing even though Sean was dead. When Dr. Brody became aware of potential financial profit, he marketed Sean's cells and sold them to a medical research firm without notifying the family, without receiving the family's consent, and without a hearing. Therefore, Taylor Henlacks filed this suit pursuant to 42 U.S.C. Section 1983. In Brotherton v. Cleveland, the Sixth Circuit analyzed the Section 1983 standard into three components for a valid liability claim. 1, the existence of a property right. 2, the deprivation of that property right. And 3, under color of state law. Brotherton analyzed Ohio law and found that the next of kin have a property right to dispose of their deceased relative's body, and that this property right is protected by the 14th Amendment. Both Ohio statutes and case law agree that when an autopsy is conducted, the next of kin still have this property right, and specifically state that if the coroner does not remove tissue and retain that tissue for legitimate forensic purposes, the property right for disposition vests with the next of kin. Today, the defense witnesses, Dr. Brody and Dr. Oxfordshire, may attempt to justify Dr. Brody's sale of Sean's brain section by saying that the benefit Sean's cells could have to society, to medicine, outweighs the harm done to Sean's dignity. And thus, Dr. Brody's actions were ethical. But this is irrelevant. They'll completely fail to prove the relevant point, whether Dr. Brody had legal authority to sell Sean's cells. Today, we will prove 5 facts to satisfy a Section 1983 claim. You will hear from Dr. Parker Reese, a forensic pathologist in the coroner's office, that 1, she discovered the regenerative nature of Sean's brain cells while performing regular autopsy tests. 2, she was surprised to learn that Dr. Brody sold Sean's brain cells to a medical research firm. 3, the family's consent didn't encompass this transfer of Sean's tissue. You will hear from Taylor Henlacks, Sean's older brother and next of kin, that 4, his family was shocked to learn that Sean's body was not whole for burial. And 5, because Sean's body was not whole for burial, Sean's and his family's beliefs were violated by the manner of his burial. Your Honor, at the end of the day, this evidence will show that Taylor Henlacks had the right to bury his brother properly with dignity. Therefore, we respectfully request that Dr. Brody be held appropriately liable for damages. Thank you.
Thank you, counsel. Counsel for the defendant may proceed with introductions and opening statement.
I'd like to introduce my team. On behalf of the defense, my name is Abby Dankoff. My co-counsel today is Kristen Brennan. We will also call 2 witnesses. First will be Dr. Dana Brody, played by Shamir Bryce. And secondly will be Dr. Sydney Oxfordshire, played by Deanna Kletlinger. May I begin, Your Honor?
Please proceed.
May it please the court. Your Honors, plaintiff claims that Dr. Brody violated the 14th Amendment property interest rights of the Henlacks family. This is simply not true. In fact, today the defense will show you that there is in fact no protectable property interest in anything discovered during the course of a coroner's autopsy for the family. Especially because the Henlacks family in this case did give their consent to Dr. Brody to perform the autopsy and anything contained in it. Your Honors, the microscopic section of cells examined by Dr. Brody's office was found to contain regenerative cells, a miraculous discovery that Dr. Brody knew could change the way the medical community views many painful neurological diseases. Plaintiff filed this claim against Dr. Brody when they discovered that this microscopic section of cells had not been returned into the body for burial. They claim this is a violation of their 14th Amendment right to property. However, once again, we will show you that this right is not applicable in this case. Your Honor, as the plaintiff has already pointed out, they must prove 3 elements today. First, that they actually had a protectable property interest in these cells, and second, that it was taken from them. Your Honors, this case is simple. Ohio law states that the next of kin of a decedent upon whom an autopsy has been performed holds no protectable property interest in anything discovered during that coroner's autopsy whatsoever. It's simple, Your Honors. Last, they must show that my client, Dr. Dana Brody, did not afford them sufficient procedural rights prior to this deprivation. However, both Dr. Brody and the plaintiff himself will tell you today that consent was given for Dr. Brody to perform this autopsy. They must prove all 3 of these things, Your Honors, and they cannot prove any of them. Dr. Brody is a born and raised Ohioan. He knew that no matter where he went to school, performed his residency, that he would come back to the state that he loves so much. He is simply an ordinary doctor, Your Honors, faced with an extraordinary circumstance, regenerative cells, immortal cells. From the moment he discovered these cells, he devoted himself to furthering their research in the medical community. His actions should be viewed as responsible. Your Honor, we will also call 2 witnesses. First, you will hear from Dr. Brody himself, who will tell you that the Henlacks family gave him consent to perform his autopsy. He will also tell you that he is under a strict code of ethics in his office, and that it is his duty, his obligation, to follow these guidelines on a daily basis. He will tell you that one of the main rules on this guideline sheet is to alleviate suffering from the world, which is exactly what he was trying to do when he furthered these cells for research. Secondly, you will hear from Dr. Sydney Oxfordshire, a highly acclaimed medical ethicist, who will tell you that as Dr. Brody's actions sought to alleviate suffering, they in no way violated any of the guidelines on this code. She will tell you that his actions were noble. Your Honor, today we assume that the plaintiff will try to tell you that Dr. Brody is a thief. However, I remind you of the definition of a hero, one who is admired for noble qualities and actions. Dr. Brody could have ignored this discovery as soon as he made it. However, then he would have also been ignoring untold numbers of patients that suffer every single day from debilitating neurological diseases that these cells have the potential to cure. If he would have ignored this discovery, Your Honors, then he would have been violating the code of ethics in his office. He did not ignore it, Your Honors. He is no thief. He is a hero. the defense respectfully requests that you deny plaintiff's motion of any deprivation or violation of 14th Amendment property interest rights. Thank you.
Thank you, counsel. The bailiff will now swear the witnesses.
Will all witnesses who are to give testimony in these proceedings please step to the front? Please raise your right hand. Do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, and that your testimony will comply with the rules of the Ohio mock trial competition?
I do.
You may be seated.
Plaintiff's counsel, you may call your first witness.
Plaintiff calls Dr. Parker Reese to the stand. May I proceed?
Please.
Please state your name for the record.
My name is Dr. Parker Reese.
What's your current occupation, doctor?
I'm currently a forensic pathologist at the Buckeye County Coroner's Office.
How long have you held that position?
I've been there for the past 4 years.
Would you describe your duties at the coroner's office?
On a daily basis, I perform autopsies, acquire data from investigating officers, and testify in court.
Have you worked anywhere else as a forensic pathologist?
Before I worked at the coroner's office, I taught autopsy procedure at a teaching hospital.
So how long have you been a forensic pathologist total?
I've been a forensic pathologist for about 10 years.
Would you describe your education?
I graduated from Bass Palm College of Medicine with a medical degree. I completed a combined residency in clinical and anatomical pathology, as well as a fellowship in forensic pathology.
Are you affiliated with any professional organizations?
Yes, I am board certified as a forensic pathologist by the American Board of Pathology.
Doctor, would you define forensic pathology?
Forensic pathology is a subspecialty of pathology that focuses upon the investigation in cases of sudden or unexpected death.
Your Honor, based on this testimony, I move that this witness be recognized as an expert in the area of forensic pathology pursuant to Rule 702. The defense has no objections, Your Honor.
Without objection, the witness will be so qualified. You may examine within the scope of the qualification.
Thank you. May I continue?
Please.
Doctor, are you familiar with today's case?
Yes, I am. I performed some tests on a portion of Sean Henlacks' brain cells.
Would you describe the circumstances which led up to your performing those tests?
Sean Henlacks died in a single car accident, and as there was no obvious reason for his cause of death, the coroner's office performed an autopsy, and I was called upon to do some specific tests.
What specifically were you testing?
I was testing a portion of the cerebellum, a tumor, and the clean margins which were around it.
Did your tests find anything?
We determined that the tumor was benign, but we discovered something quite shocking about the clean margins.
What was it that you discovered?
Well, the clean margins were regenerative, or immortal.
What does that mean, doctor?
That means they have the potential to divide indefinitely.
Did you tell anyone about this discovery?
Yes, I did. I emailed Dr. Brody about this.
May I approach the witness with a copy of Exhibit A?
You may.
Let the record reflect that I'm showing a clean and unmarked copy to opposing counsel.
Thank you.
Doctor, would you identify this document?
This is the email that I sent to Dr. Brody and her response.
Doctor, in your email, did you ever address the extent of the family's consent?
Well, yes, of course I did. I said to Dr. Brody that the family's consent was limited autopsy only.
In his email to you, did Dr. Brody ever address the extent of the family's consent?
No, Dr. Brody never addressed the extent of the family's consent.
And doctor, did you tell Dr. Brody whether or not you were completely sure of your discovery?
Yes, I told Dr. Brody I was not 100% sure that these cells were regenerative.
Answering to your knowledge, doctor, did Dr. Brody take any action regarding these cells?
Yes, he did. He sold them to someone working for a biotechnology research firm.
Do you know what research that firm was doing?
They were doing research on a cure for diabetes.
Doctor, did you and Dr. Brody ever discuss the cells in person?
Yes, we had several discussions about them.
Would you describe just the subject matter of your discussions?
Well, among other things, we spoke about the research possibilities and the potential for personal financial gain that someone could see from such a discovery.
Doctor, would a sale for personal financial benefit or medical research fall within the scope of forensic pathology?
No, forensic pathology is only focused upon investigating in cases of sudden or unexpected death.
Objection, Your Honor. Move to strike the witness's last statement. First of all, this is nowhere inside her witness statement, and extrapolation is not allowed on direct examination.
May I respond?
Yes.
The witness has not extrapolated at all. The definition of forensic pathology is contained within her witness statement. And I asked her if a sale for medical research or personal financial benefit would fall within the scope of forensic pathology.
May I respond?
Yes.
Nowhere in her witness statement does she state that the sale of cells would not fall under forensic pathology. That is the answer that she gave.
May I respond?
I'm going to sustain the objection to the way the question was phrased.
Thank you, Your Honor. May I continue?
Yes.
Doctor, did you address your concerns to Dr. Brody?
Yes, I did. I confronted Dr. Brody about forwarding on the cells without the family's consent. And Dr. Brody responded by saying not to worry about it.
Thank you, Doctor. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Dr. Reese, Dr. Brody is the county coroner, correct?
Yes, she is.
And you've worked in her office for the past 4 years?
I work at one of the pathology labs at the coroner's office.
Okay. And it was Dr. Brody who initially involved you in this autopsy?
Yes, I was called upon to do some tests.
Doctor, that was because upon gross examination of the brain, the cause of death was unable to be determined. Is that correct?
It required more examination, yes.
Okay. Now, after this gross examination, some tissue samples were taken to be further investigated. Is that right?
Yes, some tumor and the clean margins which were around it.
And it was Dr. Brody who initially contacted you about running tests on these specific samples?
Yes.
Now, as you examined these slides that were taken, or that were taken containing cells, you examined those underneath a microscope. Is that correct?
Yes, I did.
And all of this falls under typical office protocol?
Well, I typically do tests and examinations on a daily basis, yes.
Okay. Now, doctor, once slides are examined, slides that contain cells, the tissue they hold is never returned to the body. Is that correct?
That is a very common practice in the Buckeye County Coroner's Office to return the tissue.
So you're saying, as a certified forensic pathologist, that it's a common practice to take tissue slides and put them back in the body?
At the Buckeye County Coroner's Office, it is a very common practice.
Really? To take microscopic cells from a tissue slide and return it to a body?
As I said before, it is a very common practice to return them to the body, yes.
Okay, doctor. Now, Dr. Reese, as you performed these standard tests on the slides, you discovered something incredible. Isn't that right?
Why, yes, I did.
What was your discovery? You discovered that there were regenerative cells?
Yes, the cells were regenerative.
Now, in layman's terms, I believe you might have said this, that means immortal?
Yes.
Now, doctor, on direct examination, you said that you told Dr. Brody that you weren't sure that these cells were regenerative. Is that right?
Yes.
You have a copy of the email in front of me?
In front of myself, yes.
Or, I'm sorry, in front of you. Could you please direct the court to where you say that in that email?
Yes, it is in the first paragraph on the second line to the end of the paragraph.
You were almost 100% certain. Is that correct?
Yes, almost.
Okay. Now, doctor, you believe, as you have said, that these cells could benefit the community. Is that correct?
They could, but that doesn't necessarily mean likely.
Objection, Your Honor. Move to strike the latter part of the witness's statement, as the question I asked only called for a simple yes or no answer.
May I respond?
Yes.
Opposing counsel asked the question. The witness answered responsively. Opposing counsel should simply move on.
I'll overrule the objection or the request, and you can ask another question if you wish.
Okay. Thank you, Your Honor. Doctor, you believe these cells could lead to possible treatments and preventative measures? Yes or no? They could lead to these treatments.
Again, that is Possible, but not necessarily likely.
Thank you,
yes.
doctor. Now, doctor, upon making this incredible discovery, you emailed Dr. Brody?
Yes, I did.
And with Dr. Brody, you discussed these potential medical discoveries that could result from the cells. Is that correct?
Again, potential, yes.
Did Dr. Brody agree with you about the massive impact the cells could have?
Yes, she did.
And at some point after your discussion, Dr. Brody transferred these cells to Dr. Gray for further research.
I was shocked that she had done that.
Your Honor, move to strike the witness's statement as non-responsive.
May I respond?
Yes.
The witness did answer the question. She answered, I was shocked that he had done that.
Request is overruled, but you may ask another question.
Thank you, Your Honor.
Doctor, did he or did he not transfer the cells to Dr. Gray?
Well,
did he or did he not, yes or no?
Yes, he did.
Now, Dr. Gray is a well-respected member of biotechnology research, is that right?
Yes.
His private firm, Drift Thornier, is currently in its second phase 3 trial involving gene regeneration.
For finding the cure for diabetes. Yes.
Okay. And phase 3 is a big deal, isn't that right?
Well, it is a big deal, but it may take a long time.
It may take a long time, but it does mean that they are close to curing diseases. They are in their phase 3. That phase 3 is very close. Is that correct?
Well, they are closer than they were before, yes.
All right. Now, switching gears, Dr. Reese, as you said before, Dr. Brody is the county coroner, correct?
Yes, she is.
Essentially, she is your boss?
Well, we are partners, yes.
Really? So you're saying that as a forensic pathologist, you're partnered with the county coroner, though you work for the county coroner?
Well, I work in one of the pathology labs.
All right. Now, doctor, you became involved with this autopsy through her, is that correct? Or
well,
through
I
him?
was called upon to do some specific tests on a portion of this autopsy.
Okay. Now, like all other autopsies, Dr. Brody was in charge of the autopsy, is that correct?
Well, actually, it was the coroner's office as a whole.
Right, but as county coroner in charge of the coroner's office, he was in charge, correct?
Again, to a point, it's the coroner's office. As I said before, it was the Buckeye County Coroner's office that performed the autopsy.
All right, doctor. Now, at the time you emailed Dr. Brody, you had an issue with what you believed to be a lack of consent, correct?
Well, I was just stating that they'd only given limited autopsy consent.
Doctor, you believed there was a lack of consent, correct?
Well, yes, there was.
You believed that. That was your opinion?
Well, it wasn't an opinion.
I mean, Dr. Brody did not share this opinion with you, did he?
Well, she had that knowledge.
I'm sorry, I don't believe you answered my question. Your opinion was that there was a lack of consent. Dr. Brody did not share this opinion, correct?
Well, I don't know what was in Dr. Brody's mind. I don't read minds.
Doctor, because Dr. Brody is in charge, he had the authority to disagree with you in this situation, correct?
He didn't disagree with me. He never says so in the email.
Now, I believe in your statement you say that Dr. Brody told you not to worry about this situation. Is that correct?
Well, I was shocked that she would say that.
Doctor, did Dr. Brody tell you not to worry about it?
As I had said on direct.
Is that what he said, doctor?
That is what he said.
Now, you're saying that you don't know if he disagreed with you. Now, if he did not think there was a problem, do you think that he would have said not to worry about it?
I said that he didn't disagree with me. He never told me he didn't. He disagreed with me.
It is your opinion that Dr. Brody also thought there was a lack of consent?
Dr. Brody never told me otherwise.
So you don't know?
I said that Dr. Brody never had any problem with the consent that I put in here. Not my consent, but the definition of the family's consent.
All right, moving on, Doctor. Dr. Brody, when Dr. Brody and you discussed the slides, he asked you to maintain them until you receive further instructions. Is that correct?
It's part of normal procedure, yes.
All right, and he also told you that while the materials were in your possession, he would be investigating the situation further?
Yes.
Did he specify what this investigation would entail?
Now, all he said in here was, I am investigating.
Do you know exactly what the extent of his investigation would include?
Well, I thought it would probably just have to do with the forensic examination, but I don't know.
So you do not know?
I told you I don't know.
Okay. Now, Dr. Reese, it was after these instructions given by Dr. Brody to hold the materials that they ended up in Dr. Gray's hands, correct?
Yes.
Now, when you found out about the transfer, as you said, you confronted Dr. Brody.
Yes, I confronted Dr. Brody.
Now, when you confronted him, as we've been over, he told you not to worry, correct?
Objection, Your Honor. As opposing counsel has just agreed, she has already asked this question and has already received an answer to it.
May I respond, Your Honor? I'm simply enforcing a point that the next few questions will show.
Objection's overruled. You may proceed.
When you confronted him, he told you not to worry, correct?
Yes.
Now, all of this took place sometime after your email exchange?
Well, and other discussions we'd had about it.
Okay. It took place sometime after Dr. Brody told you he would be investigating further.
Well, yes, but again, I had assumed that would be forensic investigations.
It took place after he told you he would be investigating.
I said yes.
And this is the same investigation that you don't know what it was, what the extent was, what he was doing. You might have assumed, but you did not know.
Again, if it would have been normal procedure, it would have been
Doctor, please answer
forensic
the question.
examinations. But yes, I did not know.
Okay. No further questions, Your Honor.
Does counsel have any redirect?
Yes, Your Honor. May I proceed?
Please.
Doctor, on cross-examination, opposing counsel asked you about the size of the samples. Do you recall those questions?
Yes, I do.
How much tissue did Dr. Brody reference in her email?
She spoke about all the tissues, slides, and other related materials.
Thank you, Doctor. No further questions, Your Honor.
Any recross?
No recross, Your Honor.
All right. Thank you. The witness is excused. And the counsel plaintiff may call your second witness.
Yes, Your Honor. The plaintiff calls Taylor Henlacks to the stand. May I proceed?
Please proceed.
Could you please state your name for the record?
My name is Taylor Henlacks.
Where do you live, Taylor?
I live in Buckeye County, Ohio.
Taylor, do you have a family?
Yes, I do. I have several family members, but one of them, Sean, died almost 3 years ago.
How was Sean related to you?
I am Sean's older brother, his next of kin, and the spokesperson for our family.
Taylor, I realize this is still a painful topic, but could we talk about Sean?
It is still a very painful topic, but we can talk about him.
Taylor, how well did you know Sean?
I knew Sean very well. Since we were only 3 years apart, I looked after him while we were growing up.
What was your relationship like with Sean?
During the year that we shared in high school, Sean and I grew very close. After I graduated from high school, I attended the local college, so we often visited and talked.
How would you describe Sean?
Objection, Your Honor. As this question calls for the witness to testify as to character testimony of his brother under Rule 404 of mock trial rules, testimony of a character may not be admissible for the truth unless it's by the party himself.
May I respond, Your Honor?
Please.
If I may proffer, the witness would only testify to actions, not to character.
Objection is overruled.
Thank you, Your Honor.
Proceed with your question.
Taylor, had you finished your answer?
No, I hadn't.
Can you finish it, or would you like me to re-ask the question?
I can finish it. Sean lived life to the fullest. He volunteered at charitable activities and played on the school lacrosse team. He was a very active member of 4-H, as well as a member of Greenpeace and Save the Whales. He was often the first to break the ice with new people.
Taylor, how did Sean's life end?
Almost 3 years ago, while driving home from school, Sean died in a single automobile accident.
Taylor, how did Sean's death affect your family?
Sean's death was very sudden and very tragic. Losing Sean so suddenly and unexpectedly was devastating.
To your knowledge, did Sean ever agree to donate organs?
No. In fact, when he took his driver's license test, he did not sign up to be an organ donor. That may...
Move to strike this witness's statement as it is hearsay. Nowhere in the statement does it say that this witness was present when his brother signed up for the motor vehicle license, and so it is hearsay under Rule 802.
May I respond, Your Honor? My question only asked for the witness what the witness knew as personal knowledge. By answering the question, he indicated that he had personal knowledge of the matter.
Objection will be overruled.
Thank you, Your Honor.
Please proceed.
Taylor, can you continue, or would you like me to re-ask the question?
I'll continue. Sean did not sign up to be an organ donor. That made sense in light of a conversation that we had earlier.
Could you talk about this conversation?
After the funeral of a family friend, Sean and I had a rather long conversation concerning death and burials.
Are you aware of Sean's views?
Yes, I am.
Could you explain whether or not you agree with them?
Yes, my views are the same as Sean's.
Taylor, what are your beliefs on the subject?
I believe that a body should be whole and intact for burial to give closure and not have any organs harvested.
So let's switch gears, Taylor. After Sean's accident, what happened to Sean?
Sean's body was taken to the coroner for an autopsy.
What did your family understand about this autopsy?
We understood that there would be fluid tests and the coroner would examine the organs to determine why Sean died, and then his body would be returned to us for burial.
After the autopsy, where did your family choose to send Sean's body?
We sent Sean's body to the funeral home of Mr. R.J. Undertaker.
Taylor, what happened to Sean's body?
When Sean's body was delivered to the mortuary for burial, it was missing a section of the brain. We were all shocked.
Taylor, what do you mean by shocked?
That was not what we understood of the autopsy, and we expected that we would be able to bury Sean whole, the way we believe.
Taylor, was that portion of Sean's brain ever returned?
No, and that was what made the situation over the top for us.
Do you object to Sean's tissue being taken and not returned for burial?
Yes, that's unacceptable to us.
Based on your knowledge of Sean, why do you object?
I don't think Sean would have wanted a section of his brain removed and not returned for burial. I am sure he never would have consented.
Could you elaborate on what you and Sean wanted?
Sean and I both wanted to be buried whole and intact, without our body parts strewn across the nation in labs.
How have you been respected regarding your beliefs about burying Sean?
As a matter of moral principle, our beliefs have been violated. It's just wrong.
Thank you, Your Honor. No further questions.
Cross-examination? You may proceed.
Mr. Henlacks, my name is Ms. Dankoff, and on behalf of the defense, I would like to offer you our deepest condolences for your loss. I'll just be asking you a few questions today. You are the older brother of Sean Henlacks, correct?
Yes, I am.
And the two of you were 3 years apart?
Yes.
And as you stated, you were very close.
Yes, we were close.
And Sean was a very caring person in his community, right?
Yes, he was.
And as you stated, he was a member of Save the Whales?
Yes.
And Greenpeace?
Yes.
And 4-H?
Yes, he was.
And we can agree that your brother was a very generous person, is this correct?
Well, in general, yes.
Moving on. Mr. Henlacks, your brother passed away 3 years ago, correct?
Yes, he did, in a car accident.
And it's my understanding that it was a single car accident?
Yes.
But Sean was pronounced dead at the scene?
Tragically, yes.
But the exact cause of death was unknown, is this correct?
I don't think they knew at that time.
And so an autopsy was ordered, right, Mr. Henlacks?
Yes, it was.
And the coroner's office came to you and told you what would occur in this autopsy, as you've stated?
Dr. Brody gave us talked with me enough so that I understood the limits of the autopsy.
And so the coroner's office made sure you had an understanding of what would go on, is this correct?
We did have an understanding of the limits of the autopsy.
And this understanding was good enough for you to consent to the autopsy? It was enough for you to consent to it?
Just on that understanding.
And that understanding included that the coroner would take some fluid samples?
Just fluid samples for analysis.
And also that understanding included that the coroner would take tissue and organ samples. Is this correct?
No, our understanding was that the coroner would take fluid samples and examine the organs.
So your understanding was that the coroner would examine organs and tissues, correct?
Organs, yes.
And the brain is an organ, is it not?
I believe it is.
And after this discussion with the coroner, you agreed to the autopsy, is this correct?
On the understanding that I had, yes.
And you're not aware of anyone in your family refusing this autopsy, are you?
No, none of us had a reason to object on the understanding that we had.
Even though you claim that your brother, believed that a body should remain whole?
As whole as possible.
And you knew of your brother's wishes before your conversation with the coroner, didn't you?
Yes, I did.
No further questions, Your Honor.
Does counsel have redirect?
Yes, Your Honor.
You may proceed.
Taylor, on cross, opposing counsel asked you about your understanding of the autopsy. Do you recall that line of questioning?
Yes, I do.
What was your understanding of the autopsy?
Our understanding of the autopsy was that the coroner would take fluid samples and would conduct fluid tests and examine the organs.
How whole did you want to bury Sean?
Your Honor, outside of the scope of my cross, nowhere in my cross did I examine this fact of how whole Taylor would have liked his brother to be buried.
May I respond, Your Honor? On cross, opposing counsel did reference Sean's beliefs about burial and how he wanted to be buried. Thus, this is not outside the scope of cross-examination.
Objection will be overruled.
Thank you, Your Honor. Taylor, can you answer the question, or should I re-ask it?
I'd like it if you could re-ask it.
Certainly. How whole did you want to bury Sean?
As much as possible. Something like organ donation was out of the question.
Thank you, Your Honor. No further questions.
Recross?
No, Your Honor.
Thank you. Yes. Plaintiff, have any further businesses?
At this time, the plaintiff rests.
All right, the plaintiff rests. Defense, are you ready? Present your case.
We are, Your Honor.
All right, defendant may call your first witness.
At this time, we would ask that the witness be allowed to step down.
Oh, witness is excused.
And also at this time, we'd like to call Dr. Dana Brody to the stand. May I begin?
Please proceed.
Please state your name for the court.
My name is Dr. Dana Brody.
And what do you do for a living, Dr. Brody?
I'm serving as the Chief Coroner of Buckeye County, Ohio.
Doctor, I'd like the court to learn a little bit about your background. Where are you from?
I'm a proud native son of the great state of Ohio.
And how about your schooling? Where did you attend school?
Well, to attain my medical and doctorate degree, I attended Blue Jay University of Medicine, and I attained a residency at American Robin University of Medicine.
Doctor, have you ever been recognized for the work that you do?
Well, I'm currently serving as a Fellow of American Pathology with a specialty in anatomic and clinical pathology and a subspecialty in forensic pathology. And I'm also proud to serve as a diplomat of the Fellows of the College of American Pathology.
Doctor, how about teaching? Have you ever taught about your line of work?
Well, I was able, when I was out on the West Coast, to instruct students on how to actually conduct an autopsy.
And did you find this experience worthwhile?
Absolutely. The work of a coroner's office is absolutely necessary in our nation.
Doctor, what exactly does a forensic pathologist do?
Well, a forensic pathology executes the study of forensic pathology, which is basically to understand how injuries and diseases affect the body and how those correlate to legal issues in our American justice system.
And what is a normal day at the coroner's office like?
Typically, in the coroner's office, we are conducting autopsies on unfortunate people that have become deceased.
Your Honors, at this time I'd like to qualify Dr. Brody as an expert in forensic pathology due to his education, training, and experience.
Your Honor, I have no objection to this witness's qualification. However, I reserve the right to object if the witness strays outside this scope of this expertise.
Witness is qualified, and you may examine the witness within the scope of his expertise.
Thank you,
Yes, Your Honor. Dr. Brody, let's talk about your work. What is the point of performing an autopsy?
An autopsy is required to be conducted to understand the circumstances and causes of why someone has unfortunately died.
Do different autopsies require different methods?
Oh, absolutely. It just depends on the area of injury to the body and the circumstances of that injury.
And is the removal of tissues a common occurrence in an autopsy?
Oh, absolutely. The American medical community accepts examinations of tissues, organs, and fluids in order to conduct a reasonable and complete autopsy.
So when a family consents to an autopsy, do they also consent to this removal of tissues?
Yes, they do.
Now, Dr. Brody, I'd like to turn your attention to this particular case. Why was an autopsy needed for Mr. Henlacks?
Unfortunately for Mr. Henlacks, he was killed in a single car incident. And at the scene of the incident, the paramedic staff was unable to come to a definitive conclusion as to why he died.
Did you seek consent from the Henlacks family in this case?
Office protocol within the coroner's office establishes that the county coroner's office go out to seek family consent.
And did the Henlacks family consent?
Yes, they did.
Now, doctor, did your autopsy include examination of the brain?
Yes, it did.
And why is this?
Just to make sure that any possible causes of death were fully evaluated, the brain was examined.
Did you need to remove Sean's entire brain for autopsy?
No, if accepted medical standards, only small sections of the brain were necessary for further evaluation and study.
Doctor, did you discover anything during your autopsy?
A abnormality.
And what was this?
It was a brain tumor that was a part of young Mr. Henlacks' brain.
Did you examine the tumor?
Yes, the tumor was further evaluated and studied by Dr. Parker Reese.
And what were the findings?
A truly miraculous event occurred. It happened that the brain cells within Mr. Henlacks' brain were of a regenerative nature.
And what is the significance of this, doctor?
It means that these brain cells will continue to reproduce outside of Mr. Henlacks' body and outside of Mr. Henlacks' life. It is something that has never been seen in medical history.
Now, doctor, I'd like to talk to you about how the medical community interacts. Do you work daily with other pathologists?
Oh, absolutely. The county coroner's office employs a full range of pathologists to conduct the people's work.
And do these consultations benefit you in your daily work?
Oh, absolutely. Good collaboration among medical colleagues is the best way to ensure that an autopsy is conducted in an efficient and ethical way.
And have you told any other doctors about finding Mr. Henlacks' cells?
After an extensive search of cell regeneration experts and anyone of the field that might be capable of handling the enormous magnitude of these cells, I did contact a Dr. Alex Gray.
Why did you choose to contact Dr. Gray?
Dr. Gray is of White Pine University. He is of a high stature within the medical community. He has dedicated 20 years of his life to the issue of cell regeneration. He was the best person to further the research of these brain cells.
Now, doctor, do you follow a code of ethics in your office?
Oh, absolutely. I still remember the stories of when the county coroner's office was not run in an effective and ethical way.
And are you, as head coroner, bound by these guidelines along with your colleagues?
Yes, I am.
And do you follow them daily?
Daily and in every moment of this key work of the people of Buckeye County.
And do you enforce them in your office?
Absolutely. The people demand good and ethical service of their public officials. I believe that public service is a public trust.
Doctor, did you violate any of these guidelines in this case?
Absolutely not. My duty as a medical official and as an elected representative of the people I make sure that I give them a complete and ethical guidelines in my work.
Dr. Brody, you are here today being tried for violating the boundaries of a medical pathologist. Do you believe you did anything wrong in this case?
Absolutely not.
Why not, doctor?
I was following the guidelines of the Universal Code of Ethics, the code of ethics that I employ within my office, which is to make sure that medical research and anything that can alleviate suffering is proceeded by in our office.
Doctor, in your expert medical opinion, do you believe that Sean Henlacks cells have the potential to alleviate suffering?
Yes, absolutely.
Objection, Your Honor. Opposing counsel, Ms. Dankoff asked the question for a medical opinion. This witness has been only qualified in forensic pathology, not medicine.
Your Honor, may I respond?
Please.
Clearly, knowing the potential of these cells, which is what Dr. Brody had knowledge of, led him to perform the actions that he did. It is basic facts of the case that he believed that these cells could alleviate suffering.
May I respond, Your Honor?
Yes.
This is a personal opinion, not an expert opinion. And furthermore, the witness was offering an opinion in medicine. He is only qualified in forensic pathology.
Would you state your question again, please?
Do you believe in your expert opinion that Mr. Henlacks' cells have the potential to alleviate suffering in the world?
May I respond, Your Honor?
Yes, final response.
Ms. Dankoff, her question was in your expert medical opinion, not in your expert opinion.
I'll overrule the objection.
Thank you, Your Honor.
I'll repeat the question. Do you believe in your expert opinion that Mr. Henlacks' cells have the potential to alleviate suffering in the world?
I do.
And doctor, in your opinion, who are you benefiting when you decided to further these cells for research?
The people. The people that suffer from neurological diseases every single day of their lives that have been impeded by these crippling conditions in their everyday lives.
No further questions.
Cross-examination?
Yes, Your Honor.
All right, you may proceed when you're ready.
Hello, Dr. Brody. My name is Simeon Robe. I will be asking you some questions on behalf of the plaintiff today.
Mr. Robe.
Dr. Brody, you are the Buckeye County Coroner, correct?
Yes, I am.
And you're a medical professional, true?
Yes, I am.
Dr. Brody, you would never betray the ethics of your profession, true?
Absolutely not.
And Dr. Brody, you're familiar with the Universal Ethics Committee Guidelines of Professional Conduct, true?
Yes.
Dr. Brody, you stated on direct that you are bound by them. Isn't that true?
Yes, as a medical official.
Dr. Brody, the sixth principle states, refrain from exploiting any professional relationship to further personal, political, or business interests at the expense of the best interests of patients or others. Isn't that true?
I believe so, but would you like to show me?
Dr. Brody, certainly. Your Honor, may I approach the witness with a copy of Exhibit B?
Yes.
Let the record reflect I'm showing a clean and unmarked copy. May I approach the witness?
Yes.
Dr. Brody, again, the sixth principle states, refrain from exploiting any professional relationship to further personal, political, or business interests at the expense of the best interests of patients or others. True?
Yes.
And the first principle states, respect human life and the dignity of every individual, doesn't it?
Yes.
Dr. Brody, you conduct autopsies in your office, true?
Yes.
And they are known as medical legal autopsies, right?
Yes.
And Dr. Brody, your autopsies must respect the dignity of the deceased. Isn't that true?
That is true.
And your autopsies are performed to understand the circumstances and to establish the cause and manner of death. Isn't that true?
Yes, it is.
Dr. Brody, it's your job to uncover the mystery of the cause of death, isn't it?
Yes, it is.
You routinely take pieces of tissue for closer examination. Isn't that true?
Yes, it is.
And that is to authoritatively determine the cause of death, isn't it?
Yes, it is.
Dr. Brody, you received the family's consent to remove a section of Sean's brain and to study it to determine the cause of death, correct?
Yes, I received permission for the autopsy.
Specifically, you received permission from the family to remove a section of Sean's brain to examine it, true?
Well, that was a part of the consent, yes.
Thank you, Dr. Brody. But you didn't specify on direct that you received Taylor Henlacks, the next of kin's consent, did you?
I received consent from the Henlacks family.
But you didn't specify that you received Taylor Henlacks, the next of kin's consent, did you?
I received it from the Henlacks family.
Dr. Brody, is that a yes?
I believe Mr. Henlacks is a part of the Henlacks family.
Yes, but my question is you didn't specify that on direct, did you?
I don't believe so.
Thank you, Dr. Brody. Dr. Brody, you haven't produced for this court a written legal document evidencing the Henlacks family's written consent for this autopsy, have you?
I know I haven't.
Dr. Brody, you did remove a section of Sean's brain to study it and help determine the cause of death. True? May I respond, Your Honor?
Yes.
This is cross-examination. I have leeway.
Objections overruled.
Thank you, Your Honor. Dr. Brody, you did remove a section of Sean's brain to study it and help determine the cause of death. True?
Yes, I did.
And you told Dr. Reese to ensure that all the tissues and related materials were preserved. True?
As office protocol dictates.
You accepted Dr. Gray's offer to purchase the tissue, didn't you? Yes or no?
I believe so, yes.
And the payment was made to you personally, wasn't it?
It was made to me personally only.
Dr. Brody, the tissue's properties would not have changed if you had directed this payment to the coroner's office, would they have?
Excuse me?
The tissue's properties would not have changed if you had directed the payment to the coroner's office. Isn't that true?
I'm a bit confused with what your question is. If I had told Dr. Gray to direct it to the county's treasury?
Excuse me, Dr. Brody, I'll re-ask the question. The properties of Sean's tissue would not have changed if you had directed the personal payment from Dr. Gray to the coroner's office. Yes or no?
I don't think so. I don't believe it would.
Thank you, Dr. Brody. Dr. Brody, nor would the tissue have changed if you had donated it. Isn't that true? Yes or no?
No, it wouldn't.
Dr. Brody, you worked at a West Coast forensic consulting firm, correct?
Yes, back in the old days.
And you received compensation there, true?
Yes, as the job dictates.
And you called that compensation generous, didn't you?
I believe it was an adequate compensation.
Dr. Brody, your student debt was enormous from many years at expensive school, correct? Your Honor, may I respond?
Please.
Certainly. On the purpose of cross-examination is to seek out evidence that will impeach the witness through interest, motive, prejudice, and through contradiction, pursuant to Evidence Rule 616. This is precisely what I'm doing.
May I respond, Your Honor? I still don't see how Dr. Brody's history at a medical firm out west has to do with the case of the 14th Amendment property interest rights, which is why we're here today.
May I respond one more time, Your Honor?
No, I'm going to overrule the objection. The question does go to one of the issues in the case. There's a dispute about that.
Yes, Your Honor. Excuse me. Thank you, Your Honor. Dr. Brody, your student debt was enormous for many years at expensive school, correct?
The best education is pretty expensive.
Thank you, Dr. Brody. And you received the personal payment for these cells, didn't you?
The personal payment was written out to me.
Yes. Thank you, Dr. Brody. No further questions, Your Honor.
All right. Are we direct?
Yes, Your Honor.
You may proceed when you're ready.
Now, Doctor, I believe you still have Exhibit B in front of you.
Yes, I do.
Counsel brought up guideline number 1 on his cross. Could you please tell the court how that factored into your decision today?
The guideline number 1, to respect human life and dignity, was a key aspect of my judgment in this case. I decided that the brain cells of Mr. Henlacks had the possibility to help human life in any form all around the world.
Now, Doctor, I'd like to bring up a guideline that counsel didn't bring up on his cross. Could you please read for the court guideline number 4?
Yes. Work freely.
Objection, Your Honor. Guideline number 4 is outside the scope of my cross-examination. I referenced guideline 1 and guideline 6. That is it.
Your Honor, may I respond?
Yes.
I believe since counsel did bring up the entire guidelines on his cross, I'm allowed to address another guideline on this code.
Objection will be overruled.
Thank you, Your Honor.
Doctor, could you please read for the court number 4?
Yes. Work freely with colleagues to discover, develop, and promote advances in medicine and public health that ameliorates suffering and contributes to human well-being.
And Doctor, how did you take this guideline into account?
This was really the main focus in my heart, what to do.
Objection, Your Honor. This is an invention of fact. Nowhere in the witness's written statement does it state that he has this opinion upon this guideline. And furthermore, if opposing counsel cannot point out a specific line number where that is contained, it is inadmissible.
Your Honor, may I respond? Counsel did bring up the guidelines on his cross, and since Dr. Brody was allowed to extrapolate from his witness statement then, he is allowed to address the entire guidelines at this time, which is he is doing, as you have already ruled.
I'll sustain the objection at this time.
Doctor?
Your Honor, excuse me. A motion to strike the witness's testimony.
Motion to strike is granted.
Thank you, Your Honor.
Please
Doctor,
proceed with the redirect.
Excuse me, Your Honor?
Please proceed with the...
Moving on, Doctor. Why exactly did you transfer these cells to Dr. Gray?
To ameliorate suffering around the world, to make sure that further medical research was conducted.
And Doctor, counsel brought up the issue of consent on his cross. Who exactly did you get consent from in this case?
The Henlacks family.
No further questions, Your Honor.
Redirect?
Yes, Your Honor.
Or, I'm sorry?
Recross, Your Honor.
Recross.
May I proceed?
Yes.
Dr. Brody, you stated on redirect that you transferred these tissues to Dr. Gray, correct?
Yes.
That was to ameliorate suffering, true?
Yes.
You received personal payment for those tissues, didn't you?
Objection, Your Honor, outside the scope of my redirect. I nowhere mentioned any sale or any money received during my redirect.
Objection will be overruled.
Thank you, Your Honor. Dr. Brody, you received personal payment for those tissues, didn't you?
Personal payment from Dr. Gray was addressed to myself as coroner.
Thank you, Dr. Brody. No further questions, Your Honor.
Thank you. The witness may be excused.
Thank you very much, Your Honor.
Counsel for defense, defendant, you may call your next witness.
The defense would like to call Dr. Sidney Oxfordshire. Please state your name for the court.
My name is Dr. Sidney Oxfordshire.
Dr. Oxfordshire, what do you do for a living?
Currently, I am the Chief of Pediatric Critical Care at Mount Henry Hospital, and I am also an assistant professor at Mount Henry College of Medicine.
Where did you earn your medical degree?
I attended Green State University, where I earned my medical degree in addition to my Bachelor of Arts in Neurobiology.
What did you pursue after graduating?
After graduating, like most medical students, I participated in residencies. My first residency was in emergency medicine. After that, I had the privilege to travel out to Boston, where their children's hospital is very well known. There, I had the privilege to participate in a residency with the children involving pediatrics. This was a dream come true because I love working with the children. They're such darlings.
Now, residencies, what did you do after them?
After my residencies, I returned to Green State as a pediatric intensivist. And then a few years later, I began working at Mount Henry Hospital, and I took leadership over their division of pediatric critical care.
Besides pediatric critical care, what else were you involved with at the hospital?
About 3 years after I began working at the hospital, I was asked to join the hospital's ethics committee. Now, this committee requires that certain physicians are on board at all times, and so I was asked to be one of those physicians.
How long have you been on this committee?
I've been on this committee about 7 years now.
Now, what exactly does the ethics committee do?
The ethics committee is more of an advisory committee that helps to answer the moral and ethical questions that so often come up during a patient's care. These questions can be addressed to us by the patients' families, the physicians, or any other medical professionals at the time.
Now, how do you help these people work through some of these difficult questions and issues?
Well, the committee is dedicated to problem solving, and we do this in 2 ways. First, we encourage dialogue between the patients, the families, and their physicians. Second, we look to find viable options for certain problems that come up during a patient's care.
What does the ethics committee use?
Well, it can be difficult to look for answers to the difficult issues that come up during a patient's care, so we refer to the Universal Ethics Committee Guidelines of Professional Conduct.
Now, what exactly are the Universal Ethics Committee Guidelines of Professional Conduct?
It is a mouthful, but plainly speaking, They are a list of guiding principles that help to govern the work of every medical professional.
Your Honor, at this time, I would ask that my witness be qualified as an expert in the field of medical ethics based on her extensive training, knowledge, and experience.
Any objection?
Plaintiff does object to this qualification on the basis of Rule 702, Part 1, which requires that a witness be qualified by knowledge, skill, education, experience, or training in the area in which they will be testifying. The witness today will be offering personal ethical determinations. However, the only experience to which she has testified is experience serving on an ethics committee, which is not relevant to her testimony today. Further, the duties of that ethics committee, as the witness has just testified, are encouraging dialogue and offering viable options. They do not include, even her service on the committee, does not include experience making specific ethical determinations. Therefore, this witness is not qualified to testify as an expert in medical ethics.
May I respond, Your Honor? To start, my witness has stated that she has served on this ethics committee, which she has explained is in charge of governing the hospital's any decisions or any problems or issues regarding ethics. They have to give their opinions on that. So she has served for 7 years doing just that, giving opinions on ethics. Also, so she has had extensive experience in training. Also, according to Rule 702, it's extensive training, knowledge, or experience. I believe that she had, or training, knowledge, experience, or education. So I believe that she does have enough of those qualifications. Also, on the errata sheet, if I could direct your attention to January 18th. It says that Dr. Brody can give her opinion as to whether or not, or it says that Dr. Oxfordshire can give her opinion about Dr. Brody's conduct, whether or not it was ethical, can offer any other relevant opinions concerning ethical issues. Therefore, I find her fully qualified to be qualified as an expert in medical ethics.
May I respond to this, Your Honor?
I will overrule the objection at this time based upon the witness's experience and knowledge.
Thank you, Your Honor.
And she can testify within her area of expertise.
Yes, Your Honor. Now, Doctor, I'm going to ask you a series of questions in regards to this case in particular. Are you familiar with the case?
Yes, I am.
How are you familiar with it?
Well, I was asked to review the case materials and come to a conclusion on whether the actions presented in the case were ethical or not.
Now, do you have an opinion to a reasonable degree of ethical certainty as to whether or not Dr. Brody violated these guidelines?
Yes, I do. After looking over the case materials and seeing the actions of Dr. Brody, I came to the conclusion that he did not violate the ethics guideline.
Now, I'd like to talk to you a little bit more about how you reached that conclusion. Your Honor, may I have permission to approach the witness with what has been previously stipulated as Exhibit B?
Yes, you may.
Let the record reflect I'm showing opposing counsel a clean, unmarked copy. May I approach?
Thank you.
Dr. Oxfordshire, do you recognize this?
Yes, I do.
What is it?
This is a copy of the Universal Ethics Committee Guidelines of Professional Conduct.
How do you recognize it?
Well, these are the guidelines that I use every day in my work as a physician, in addition to my work on the Ethics Committee.
Did you refer to this document in forming your opinions today?
Yes, I did.
Dr. Oxfordshire, which of the guidelines are relevant to this case?
Well, all of the guidelines apply to every case, but the most relevant in this case are numbers 4, 5, and 8.
Guideline 4, how does it apply?
Guideline number 4 speaks about working freely with colleagues to discover, develop, and promote advances in medicine and public health that ameliorate or alleviate suffering.
Now, how does that apply here?
Dr. Brody, after reviewing the case materials, I found that his actions were in line with this guideline because he was working freely with his colleagues to research the cells.
All right, Doctor, I believe you also mentioned guideline number 5. How does that apply to this case?
Guideline number 5 speaks about continuing to study, apply, and advance scientific knowledge and maintain a commitment to medical education, which is what Dr. Brody was doing when he was researching the cells.
Guideline 8, how is it relevant?
Guideline number 8 speaks about supporting and participating in healthcare programs and activities that contribute positively to the welfare of individual patients, the healthcare system, and the public in general.
Now, I noticed that the guidelines also require a physician to respect the human life and dignity of every individual. Didn't you consider that?
Yes, I did consider that guideline. In every case that I review, I have to ask, did the physician or medical professional attempt to maximize the benefits to society while minimizing the risk to a specific individual?
Why do you ask that?
These days, medical research, especially that involving human tissue, is proving to be ever more vital in medical research, and I must make sure that individuals participating in this research are following their codes of conduct.
Now, lastly, Guideline 6, did you consider it?
Yes, I did consider Guideline 6. It speaks about refraining from exploiting any professional relationship in order to, well, I guess you could say, get ahead.
How did it factor into your opinion?
Well, after reviewing the case material, I did not find that Dr. Brody's actions were in violation of this guideline.
Now, Doctor, we've been picking apart these guidelines, but what is their significance as a whole?
Generally speaking, these guidelines are a code of professional conduct, and medical professionals are expected and even obligated to follow these guidelines so that they may maintain a professional relationship with their colleagues and their patients.
You said obligation. What do you mean by that?
Well, by obligation, I mean they are morally bound to follow these guidelines to keep their professional relationships between the patients and the colleagues.
Now, how does all of this fit into the case being discussed today?
In the case being discussed today, Dr. Brody was following the guidelines that he was obligated to in his line of work. In no way was he in violation of these guidelines.
Thank you. Thank you, Your Honors. No further questions.
Counsel for defense may cross-examine.
Yes, Your Honor. Before I begin, may I inquire as to how much time remains on the clock for my cross-examination? Thank you. May I proceed?
Please.
Good afternoon, Doctor. My name is Sarah Welch, and I'll be asking you some questions on behalf of the plaintiff.
Good afternoon.
Doctor, you have a protocol for evaluating cases in your role as a member of the Ethics Committee, correct?
Yes, I do.
Now, your committee was not asked to investigate in this case, correct?
No, unfortunately, it was sent under the city's jurisdiction, but I have reviewed the case materials.
Thank you, Doctor. But you did investigate this case, correct?
Yes.
Thank you. Now, if they were asked to evaluate the case, you would evaluate it in the same way, correct?
Oh, yes, of course.
And you did evaluate it using your regular protocol, didn't you?
Yes.
But, Doctor, that protocol was designed for your service on the Ethics Committee, wasn't it?
Yes, where we review the ethics of all medical professionals.
And you used that process for making determinations on a committee to make an individual determination in this case, didn't you, Doctor?
Yes, I used the guidelines which have ruled my line of work and other medical professionals' line of work.
You've answered my question.
Objection, Your Honor. I believe this is the third time opposing counsel has cut off my witness. I'd like to ask that she be allowed to answer the question adequately.
May I respond? Yes. The first word out of the witness's mouth was yes. She did answer my question at that point. As I have limited time on cross-examination, opposing counsel is provided with additional time on redirect examination if the witness feels that she must further explain her answers.
The court will just remind the witness to answer the question, and we'll proceed in that way.
Thank you, Your Honor. Now, Doctor, you feel that if a physician's research could improve lives, it should not be stopped. Is that correct?
Oh, yes, of course.
In other words, you feel that there are no circumstances under which a physician's research which could improve lives should be stopped. Is that true?
In most cases, this is true.
But there are circumstances under which a physician's research should be stopped. Is that true?
Well, if it was going to hurt them, if it wasn't going to maximize the benefits to society while minimizing the risk to a specific individual.
So there are circumstances under which a physician's research which could improve lives should be stopped, aren't there, Doctor?
Well, if it was going to harm other people, then yes.
Thank you, Doctor. Now, you believe that physicians should always maximize societal benefit and minimize the risk of individual harm, correct?
Yes.
And you always attempt to follow that principle, correct?
Oh, yes, of course.
So, Doctor, if you determined that perjury maximized the benefits to society and minimized the risk of harm to a specific individual, you would lie to this court, wouldn't you?
No, no, that is not true.
So there are exceptions to that principle, aren't there, Doctor?
There may be exceptions.
Relevance?
May I respond?
Yes.
The witness has indicated that this is a principle which underlies her ethical opinions. I'm simply examining that principle.
This is cross-examination. You may proceed.
Thank you. Doctor, in fact, as we've just agreed, there are exceptions to that principle, aren't there?
Could you repeat the principle?
There are exceptions to the principle of maximizing societal benefit and minimizing the risk of individual harm, such as perjury. Isn't that true, Doctor?
Yes. Well, in
Thank
that
you,
case,
Doctor.
the harm to an individual
Doctor.
would be very great, and so it would not be minimizing the harm.
I see. So you don't feel that that's a relevant example of maximizing societal benefit and minimizing the risk of individual harm?
I do not believe it would be minimizing individual harm, no.
I see. So you didn't mean, when you agreed earlier, that if perjury maximized societal benefit and minimized the risk of individual harm, you didn't actually think that there were any cases in which that could be possible when you answered that question?
Well, I did not believe that it was minimizing the risk to a specific individual.
So you don't agree with your previous answer to that question now. Is that true, Doctor?
I believe my previous answer was that there would be, perjury would not be admissible.
Doctor, I don't believe you've answered in that way, but we'll leave that up to the court to determine whether that was true or not. Let's continue. You testified on direct examination that about the Universal Ethics Committee guidelines of professional conduct, correct?
Yes.
So let's talk some more about those guidelines. The very first guideline requires physicians to respect human life and the dignity of every individual, correct?
Yes, the dignity of every human individual.
Thank you. Now, Doctor, these guidelines are not legally binding, are they?
No, but individuals are obligated to follow them.
Indeed, you did use the word obligate, didn't you? In fact, the word on the document is expected, isn't it?
Yes, and
Thank
by
you, Doctor.
obligated I meant morally bound.
I see. But the word on the document is expected, isn't it?
Yes, that is what it says.
I see. So, Dr. Oxfordshire, you own your own body, don't you? You own your own body, don't you?
Yes, I do.
And that's a basic human right, isn't it?
Objection, Your Honor. My witness is qualified as an expert in medical ethics. She's asking my witness to testify about law. She's here today to testify about ethics. Her knowledge of this case is simply to give her opinion about ethics.
May I respond?
Respond.
The witness is indeed an expert in the area of medical ethics, and on these Universal Ethics Committee guidelines of professional conduct, which the witness has been repeatedly referencing, the phrase basic human rights is used. If the witness is not qualified to render opinions regarding that aspect of the document, then her expertise is indeed very narrow.
I'll overrule the objection on that basis.
Thank you, Your Honor. Doctor, owning one's own body is a basic human right, isn't it?
Yes, I believe so.
Now, the second guideline does require medical professionals to refuse to participate in or support practices which violate basic human rights. Correct?
Yes, of course.
Now, violating a basic human right is then an ethical violation, isn't it, Doctor?
Yes, according to the guidelines.
And these guidelines apply, all of these guidelines apply in every situation, correct?
Yes, as I have stated before.
Thank you, Doctor. Now, you believe that Dr. Brody sold the tissue in question so that it could be researched, correct?
Yes, so that he could benefit millions of people suffering with debilitating diseases.
Thank you, Doctor. In fact, Dr. Brody personally profited from that research, correct?
I believe after reviewing the case material, it said that there had been personal payment made out in his name.
Thank you, Doctor. The payment was received personally by Dr. Brody, correct?
The money was made out in his name.
It was received personally by Dr. Brody. Is that true?
Like I said before, I reviewed the case materials. I was not there at the time, but the case materials had said that it was made out into his name.
I understand, Doctor. Is that a yes?
I do not believe I can adequately answer your question because I was not there when the money...
You can't adequately answer whether Dr. Brody received payment personally for the cells. Is that true?
I just know that by reviewing the case material, like I have said before, that it was just made out in his name.
I see. Thank you, Doctor. Now, when you first joined the Ethics Committee, you were vocal about your opinions on medical research, weren't you?
Oh, yes.
So when you first joined the committee, you already held that opinion on medical research, correct?
Yes, and it actually is one of the guidelines also.
Thank you, Doctor. So it wasn't based upon your experience serving on the committee that you held that opinion, was it?
No, but the committee had actually enforced my opinion.
I see. And you still hold this opinion, which was not based on your experience on the committee. Isn't that true, Doctor?
No.
You don't still hold that opinion about medical research?
Excuse me. Yes, I do still.
See. Thank you, Doctor. No further questions, Your Honor.
Does counsel have redirect?
Yes, Your Honor.
You may proceed when you're ready.
Dr. Oxfordshire, are all cases that you've reviewed the same?
No, each case is different.
Do they all have the same circumstances?
No.
Now, what did you mean when you said that you have to ask if the benefits to society outweigh the risk of harm to an individual. What did you mean by that?
Well, when I was saying that, I meant that obviously society had to benefit, but also the people could not be severely harmed.
All right, now, doctor, how does this apply to this case?
Well, in this case today, I reviewed the case materials, and the actions provided by Dr. Brody did not seem to be in violation of the guidelines.
So it is of your expert opinion that Dr. Brody did not violate the guidelines?
No, he did not.
Now, what is this based on?
It was based on my reviewing the case material and looking at it in a way that I would any other case on the ethics committee.
Now, your opinion about research, I believe that on cross-examination that was brought up, correct?
Yes.
Now, what is your opinion?
My opinion is that human research should be encouraged in order to help the medical community and in turn help millions of people with diseases.
Now, did you hold this opinion before you were on the ethics committee?
Yes, I did.
How has it developed since you've been on the committee?
Well, the committee has enforced my opinion, and the guidelines also do.
And so, does your opinion factor into the expert opinions you form when reviewing cases?
When I review cases, I look to the guidelines to judge in order so I may see if an action is ethical or not. I do not necessarily focus on my personal opinions.
All right. Thank you, doctor. No further questions.
Do you wish to recross?
Yes,
Okay, you may proceed when you're ready.
Doctor, on redirect, you stated your opinion that people should not be harmed by medical research, correct?
They should not be maximized. The harm to them should not be maximized.
It should be minimized, correct?
Yes.
So there are cases in which it would be ethical to harm people. Is that true?
No, it would be the risk of harm to an individual, not the direct harm.
So there are cases in which it is ethical to risk harm to individuals. Isn't that true?
If the benefits to society were maximized and minimize the risk to a specific individual, then yes.
So just to be clear, there are cases in which it is ethical to harm individuals. Isn't that true?
The ethics committee has come to that conclusion even before I've been working on it.
But doctor, that is your opinion, correct?
It was the ethics committee did come up with that opinion, and so I have adopted it as I have been on the board.
Doctor, you are testifying today, correct?
Yes.
And that is your opinion, isn't it?
Yes.
Thank you. No further questions.
Do you have any further witnesses to call?
No, Your Honor. At this time, the defense has asked somebody to ask that the witness be allowed to step down.
All right, the witness is excused.
Thank you.
All right, we'll pause for a couple of minutes here to get your thoughts together for closing arguments. There's no clock in this room.
Once again, you're watching the 2011 Ohio High School Mock Trial Championship, coordinated by the Ohio Center for Law-Related Education. We're coming to you from the State House in downtown Columbus. Right now, the students have a couple of minutes to prepare their closing arguments. After that, the judges will adjourn for a short while to deliberate, during which time I will have a chance to talk with some of the students participating today and get some of their perspectives. When the judges are finished deliberating, they will then come back and announce the winning team. But first, we'll go back to the floor to hear the closing arguments here live on the Ohio Channel.
All right, the court will come back to order. Counsel, are you ready for closing arguments? All right. Plaintiff, you may proceed with your closing argument.
Thank you. May it please the court. In his opening statement, my co-counsel raised the question which lies at the heart of today's case. Who owns your body after you die? After hearing the evidence presented today, the answer to that question is clear. Sean's body belongs to his brother and next of kin, Taylor Henlacks, for the purposes of a proper and a dignified burial. In the case today, the defendant, Dr. Brody, sold a man's brain without notice, without a hearing, and without the family's consent. Therefore, Taylor Henlacks filed suit under 42 U.S.C. Section 1983. Brotherton v. Cleveland condensed this law into three elements: the existence of a property right, the deprivation of that property right, and deprivation under color of state law. We will consider these three elements in order. First, the plaintiff has a protected property right in his brother's body for purposes of burial under Ohio law. In Brotherton, the Sixth Circuit Court analyzed Ohio's laws and determined authoritatively that they grant to the next of kin in Ohio protected property rights in their decedent's bodies for purposes of burial. Two laws have created exceptions to this ruling, but neither exception applies today. The first exception was created by Ohio Supreme Court case Albrecht v. Treon. Ms. Dankoff claimed in her opening statement that Albrecht's language was discovered. However, the Ohio Supreme Court was not so vague in its decision, instead using the phrase, quote, removed and retained for forensic examination and testing, end quote. Albrecht stated that this legitimate forensic retention for autopsy would terminate the family's property right in the tissue. However, in Albrecht, the fact pattern of retention existed when tissue was being forensically tested by the coroner to establish the cause of death after the body was released to the family. No witness for the plaintiff or the defense has established these two facts today, and thus Albrecht's determination about property rights in retained tissues does not apply, and Mr. Henlacks has a protected property right in his brother's body for purposes of burial. However, even if the tissue had been retained, plaintiff still has a property interest in the tissue according to Ohio Revised Code, Section 313.123b1. This statute also denies families property rights in retained tissues and other autopsy specimens, but included a limitation on its exception to Brotherton's ruling. The tissues must be disposed of in accordance with applicable state and federal laws. In today's case, Dr. Brody violated federal law in his transfer of the tissue. 42 U.S.C. Section 274E prohibits the transfer of body parts for valuable consideration. Therefore, because Dr. Brody did not comply with the limitation to the exception to Brotherton's ruling does not apply, and Mr. Henlacks does have a protected property interest in his brother's body for purposes of burial. Second, the plaintiff and defense witnesses agreed that the Henlacks family did not consent to the sale of Sean's brain. Dr. Reese testified that she confronted Dr. Brody about his sale of the tissue, and Taylor Henlacks testified that he was shocked when he learned that Sean's brain wasn't with his brother's body. Therefore, because the family didn't consent to the sale of the brain, the defendant deprived Taylor Henlacks of his protected property right to his brother's brain for purposes of burial. Third, the plaintiff proved that Dr. Brody possessed the brain because of his authority as a state official. If not for this authority under state law to conduct autopsies, Sean's body would be intact now. Therefore, because he could not have possessed Sean's brain without state law's authority, Dr. Brody deprived Taylor Henlacks of his brother's brain under color of state law. Section 1983 also includes a provision for granting qualified immunity to judicial officials when their conduct did not violate a clearly established right of which a reasonable person would have known. Waschel v. Dragovic determined that a right is clearly established if it has been authoritatively determined by the U.S. Supreme Court, the Court of Appeals, or the highest court of the state. In this case, Dr. Brody is not entitled to qualified immunity. First, his conduct violated the property rights which the Court of Appeals clearly established in Brotherton, and which the Court of Appeals were granted by Ohio law in Brotherton, and which the Court of Appeals clearly established were granted by national common law in Newman v. Sathya Vagelswaran. Therefore, Dr. Brody is not entitled to qualified immunity. Your Honor, the question which underlies this case has been answered, and clearly answered, by both state statutes and national common law. Dr. Brody sold Sean's brain, depriving him of a proper and a dignified burial. Dr. Brody sold Sean's brain, depriving Taylor Henlacks of a property right and of the right to the due process of the law. And in selling Sean's brain, Dr. Brody deprived the family and friends of an 18-year-old senior in high school of the ability to mourn for their friend by burying him properly, with dignity, as he had chosen. Your Honor, the plaintiff respectfully requests that Dr. Brody be held appropriately liable for these appalling deprivations. Thank you.
Thank you, counsel. Is counsel for defendant ready?
Yes, Your Honor.
You may proceed.
May it please the court. The plaintiff's request that Dr. Brody be held accountable for a deprivation of the plaintiff's constitutionally protected rights should be denied. The evidence today has shown that the Henlacks family held no property interest in the brain of Sean Henlacks. The family cannot be deprived of a property interest that does not exist. Additionally, Dr. Brody provided adequate due process in the removal of all of Sean's body parts. The family consented to the removal of all of Sean's organs, including the brain, from which the tissue slides being discussed today were taken. Dr. Brody has dedicated his life to using his talents and resources to give back to others. His decision to become a doctor was a direct reflection of this strong desire to serve other people. Now, when Dr. Brody was completing his medical autopsy of Sean Henlacks, he was faced with an unprecedented medical discovery: cell regeneration in a small portion of Sean's brain. Instead of ignoring the medical phenomenon, Dr. Brody dedicated himself to furthering the research of the discovery, which he felt held the potential to change the way medicine views many painful neurological diseases. Dr. Brody felt that this discovery had potential to change the world. Dr. Brody did not commit an ethical violation in this case. He was simply an ordinary doctor faced with an extraordinary discovery, a discovery that could save lives. Now, as the defense has said before, the plaintiff holds the burden of proof in this case. In order for their claims to be justified, they have had to prove 3 points. First, that the Henlacks family held a protectable property interest in the brain of Sean Henlacks. Second, that they were deprived of this interest. And third, that the state actor, my client Dr. Brody, did not provide them with sufficient rights prior to this deprivation. They have had to prove all 3 elements, and they have been unable to prove the very first one. A violation, an unlawful taking of property in violation of due process occurs only when a property interest actually exists. Now, plaintiff has used the Brotherton case, a case that occurred 20 years ago. Just 3 years ago, in Albrecht v. Treon, the court ruled that the next of kin of a decedent, upon which an autopsy has been performed, do not hold a protectable property interest in anything removed from the body during that autopsy. Because the Henlacks family did not hold a protectable property interest in the brain of Sean Henlacks, Dr. Brody was fully within his rights as county coroner to further the research. You have heard today from Dr. Dana Brody and Dr. Sidney Oxfordshire. Dr. Brody has said that he would never do anything to compromise the ethics of his profession. Any money exchanged between he and Dr. Gray can be credited to the extreme costs of good controlled research. Dr. Oxfordshire has stated that she believes Dr. Brody's actions were completely ethical. In fact, Dr. Oxfordshire, a qualified expert in medical ethics, has stated that she believes Dr. Brody's actions were noble. She has discussed circumstances where benefits of society can outweigh risks of harm to a particular individual. She has also said that she strongly believes physicians should always be encouraged to participate in research programs that benefit the public good. Dr. Brody's willingness to further research on these cells that held the potential to cure a disease, many diseases, should not only be seen as something completely in compliance with standard medical ethics, but it should be seen as an action to be applauded. Dr. Brody could have taken the easy way out when he discovered these cells. He could have sewn Sean back up, put the discovery out of his mind, and gone on living his life as he normally would have. Dr. Brody did not do this, however. He did not take the easy way out. Instead, he persevered. He refused to give up on what he believed to be an unparalleled discovery. Dr. Brody did nothing wrong. A hero is one admired for brave deeds, one who can be looked upon as a model for others. Furthering the research on cells that could save a countless number of people is a brave model act. Dr. Brody is not a criminal, as the plaintiff would have you believe. No, Dr. Brody is a hero. The defense respectfully requests that the court deny any claim of a deprivation or violation of the plaintiff's constitutionally protected rights. Thank you.
Thank you, counsel. Does plaintiff wish time for rebuttal?
Yes, Your Honor.
You may proceed when you're ready.
May it please the court. On her closing, opposing counsel claimed that Albrecht versus Treon is the controlling case today, citing Albrecht as applying to cases of forensic removal. However, as Albrecht stated itself, it applies to cases of forensic removal and retention, although opposing counsel significantly failed to cite the latter portion of that standard. In this case, the tissue was not retained. Instead, it was sold for personal financial benefit. Therefore, Brotherton, not Albrecht, is the controlling case today. Opposing counsel also claimed that Dr. Brody acted ethically in today's case by claiming that medical research should always be encouraged. However, the defense's own ethicist on cross-examination admitted that there are exceptions to that principle. Further, the matter of ethics does not apply to any relevant legal element of the case. Section 1983 states that 3 points must be proven to state a valid due process claim, and none of these points even mentions, let alone requires, testimony of ethics. Your Honor, at the end of the day, this is a simple case. Dr. Brody sold Sean's brain. Even after hours of painstaking argument, this fact remains simple, inexcusable, appalling. It is because of this fact that the plaintiff respectfully requests that Dr. Brody be held appropriately liable. Thank you.
Thank you, counsel. That concludes the presentation of this case, and the judging panel will take the matter under consideration. And the scoring judges will be excused for their deliberation, and I will remain to discuss any post-trial matters if there are any.
All rise.
You may be seated. First, timekeepers, were there any time discrepancies in closing argument?
No, Your Honor.
No time discrepancies, very good. Does either team have serious reason to believe that a material violation of any rule has occurred during this trial? And I'll remain here on the bench for 3 minutes, during which time any protest or objection may be brought to my attention by a team attorney. Team attorneys may communicate with any student team members involved in this particular trial, but may not communicate in any way with legal advisors, teachers, or anyone outside their performing team members in this trial. So, timekeepers, you may begin the timing. Yes, please.
Once again, you're watching the Ohio Channel and the 2011 Ohio High School Mock Trial Championship. We're coming to you from the Ohio State House in downtown Columbus. Our two teams today are Olivia, Davidson, Washington in Archbishop Hoban High School. Team Washington is from Athens County. The Athens homeschool program has existed for 7 years. The club consists of homeschoolers in the Athens area. Team Thomas is from Summit County and has participated in the high school mock trial program for 26 years. Team Thomas has won 2 state championships, one in 1984 and one in 2006, and won second place in the 2009 and third place in 2010. Right now, the judges have retired to do their scoring, and while they're doing that, let's talk a little bit more about the case. This year's case ventures into the area of the 14th Amendment and the Takings Clause. Once again, I have with me Kurt and Lisa to explain what we've been watching. So, wow, they kind of sounded like they knew what they were talking about.
Absolutely. It's what we talked about before the competition. At this stage of the proceeding, the judges are looking for mastery. And I believe undoubtedly that that's what we've seen today. These students know this case inside and out, but equally as important, they understand the rules of evidence, the rules of trial procedure, and they have demonstrated that over and over today. It's been very, very fun and very exciting to watch.
Kurt, what are some of your first impressions right now that you saw?
I was like Lisa. I was very impressed with their mastery of the facts. One good example is you see in these competitions sometimes motions to strike where a witness will stray a little bit beyond what the actual written case says. And it's difficult when you're on the stand like that. You're being asked a question that's a little bit outside of the facts that have been written for you. You really want to answer, but you have to restrain that temptation to stray outside the lines. And we saw that today, and the plaintiffs moved to strike and requested point at the page and line number where that fact comes from. That demonstrates an obvious confidence in what is and is not in that written statement. That attorney knew that fact was nowhere to be found in the written pages. That's the kind of mastery we're talking about. I mean, there was no question that he knew the facts.
Now, the presiding judge, who's Justice Cupp, he seemed to overrule a lot of the objections. Would that be typical in a normal kind of trial?
It will vary a lot, judge by judge. I think probably it's fair to say that the students in this kind of situation get a little bit more leeway, partly because of the oddity of how the written fact scenario plays out. You're more likely to give them a little bit of leeway because it's uncertain sometimes where exactly those boundaries can lie. But I don't think Justice Cupp took it easy on them by any means.
So, do the witnesses, how the witnesses perform, does that factor into the presiding judge's decision on who wins this case?
It will, because as you know, there will be an award given for the best witness in the presentation today. So the judges are not only evaluating the students who are performing as lawyers, but as well as the witnesses. And as we saw today, the give and take between the question that was asked and the manner in which the witness answered that question really does help play into the determination of where this case is going to ultimately turn out.
Now, and we talked a little bit earlier about this, but the students certainly knew the ins and outs of the case. What other types of things are going on? Like I always notice every year there's always one of the student attorneys will stand and block the view. I think it looks like they're blocking the view. Is that an allowable type of thing that you see in a courtroom as well?
There's a lot of intangibles going on here. Things like where you stand, the movement, but also things such as interrupting the witness. You saw a back and forth a few times over objections. You know, Your Honor, please let my witness finish the question. Opposing counsel keeps interrupting. Those are strategies, and you have to be careful with the judges because some judges will not take kindly to interrupting or more aggressive questioning. Some judges appreciate it as a time saver and you're getting to the point. So you really have to be able to read the court. But yeah, there's a lot of intangibles like that are taken into consideration in the overall performance.
What about you? Did you see anything going on? And actually, Lisa, to you, one question I had is how much does that time clock, we saw the timers holding up, how much time they had, how much does that really kind of form how you're going to speak to a subject? What's going through the students' minds when that's going on?
Well, clearly, what we saw today is the students have timed each and every question down to the last second. And so it really does depend upon how many more questions can I ask for this witness when I've only got 30 seconds left. And it demonstrates the amount of time, rehearsal, strategy that they've put in to make sure that they get every last second and that they don't go a second over. So it becomes very, very important.
Now, when we saw them here today, they've had some time to prepare with this case. Do they know who's going to be the plaintiff or who's going to be the defense in this?
They don't know that until they completed the semifinal rounds last night. And then it's determined at that point when you're at the last two teams, then a coin toss determines which team is plaintiff and which team is defendant.
So both teams would kind of have to be prepared on either side.
What they have two teams. They have a plaintiff team and a defense team. So each school brings two teams, and depending upon how that coin toss goes at the end determines which of the three students end up competing in the final round.
Now, the students have had a chance to research this particular case, but when they're up there making their arguments, I mean, that's all improv. They're figuring out what is wrong or what is right, and so they're kind of all creating that, really, and they haven't had that benefit of 3 years of a JD behind them.
That's exactly right. That's part of the theater, part of the mastery that we were talking about earlier, that it shows and demonstrates that you have to learn to think on your feet. You have to know when to respond to a question. You have to be thinking not only of what this witness is saying, but whether or not there's an appropriate objection to be made, and what's the likelihood that that objection is going to be sustained or overruled. So those are all the things that continue to go through the student's mind, more so than just asking a question and waiting for the answer.
And I'd like to add, that's a reflection, too, of preparation. You know, it's the classic adage, you have to recognize opportunity when it comes knocking. Had these students not been prepared and had they just been improvising entirely, lots of opportunities would have passed them by. In order to think on your feet in this kind of circumstance, you have to do the footwork beforehand to be able to know what's in front of you.
So, real quick, one final question, and this will be for both of you. I'm just, what would you say were some of the highlights that you saw today? And we'll start with you, Lisa.
The highlights for me were the fact that these students were getting up without notes. They were able to deliver opening statements and closing arguments as if they were having a conversation with you and I. It's also some of the highlights that they have been able to integrate a consistent theme and a consistent theory from the time of the opening statement with every single witness that we saw. For example, the plaintiffs talked a lot about they sold his brain. And we heard that selling of the brain in the opening statement, and each witness had some opportunity to say, well, his brain was sold. And then that was re-emphasized during the closing argument. So that consistency clearly is a highlight.
Yes, absolutely. Honestly, one of the things I found most striking is you have an idea of how the case will turn out when you're writing it, and I think it probably never works out quite like that. But I expected to see a lot more policy arguments from the plaintiff side, a lot more moral arguments. With the selling of the brain, I expected more focus of this is wrong, and that would be really the central argument. And instead, I think those roles were reversed quite a bit, especially in closing. The plaintiffs focused a lot on the specific elements, the actual legal issues. Element 1, this, element 2, this, and they really went through the case law. And the defense focused a lot on the policy and the medical benefit to the community. And I really didn't see that coming. I enjoyed that part of it.
Well, great. Lisa, Kurt, thank you very much. And we're all eagerly awaiting the judge's opinion on this and who's going to win. I think actually we have some of our students here with us. Thank you very much.
Thank you.
So, you ladies play the defense.
Yes, we did.
So what's the feeling right now coming out of the firing line?
You just don't know. I mean, I thought our side did well, but the other side was awesome too. They brought up some great points that we hadn't seen before. So,
I think at this point the adrenaline's just still rushing and we have no idea what's going to happen, but that's half the fun.
So, what are some of the highlights that you have going on your minds right now?
Of the trial? I definitely, I love doing the closing statement. I love going out with a bang. Yeah, that's my favorite part. But I'd say my cross-exam, that was also a fun part because you never know what's going to happen. So that's my favorite.
I think our witnesses just pulled it off well. Like, they were calm and composed up there, and I think they handled crosses very well. I think our witnesses really did amazing today.
Dr. Brody was something else, yes.
Oh, yeah.
Yeah. I believed in his school. What, he went to Bluebird Medical? Yeah, I was like, wow, yeah, there he goes. Okay, so what are your plans in real life now?
I'm actually not really that interested in law. Everyone always asks me that. Nope, I'm actually not. I love English. I love writing, so I'm thinking something along those lines, but I also am really interested in going into business, so we'll see. We'll see what happens. We're starting to look at schools now, so.
Okay, and I just want to get your name, your school, and how old you are.
Okay, I'm Kristen Brennan. I go to Archbishop Hoban High School in Akron, Ohio, and I'm 17.
So this is your senior year, or next year's your senior year?
This is my junior year, so next year will be my senior year, yes.
Any college plans?
We're starting to look, so we'll see. I don't want to go too far away, but I'm thinking maybe out of Ohio.
And your name and your school, what grade are you? And then I want to know about your future plans as well.
All right, I'm Abby Dankoff. I'm 17 years old, and I also am a junior at Archbishop Hoban High School in Akron, Ohio. And as for the future, I'm really open to anything at this point. I don't really know what I'm going to go into yet. I mean, law is a maybe, medical is a maybe. I mean, anything's open to me at this point, and I'm starting to look at schools along with Kristen.
Well, you guys did an awesome job. I really, it's hard to figure out like who clearly won because you guys were both like head to head. So this is going to be an interesting thing. Good luck to the both of you, and thank you very much.
Thank you.
Okay, and then now we have our, you would be your plaintiff? Yes, the plaintiff. Can I have your name?
My name is Sarah Welch.
And what school do you go to, and what's your grade?
Okay, I'm a senior, but our team is Olivia Davidson Washington Mock Trial Club, which is not technically a school, but I'm homeschooled.
Okay, and then you, sir?
I'm Simeon Robe. I'm a sophomore in...
what she said.
Right, what she said.
So you're a sophomore. You potentially have 2 more years of this then. So what are your thoughts right now coming right off of the firing line? How do you feel?
That was really fun. I love this stuff. It was great.
What would be a highlight as part of your argument? What sticks out in your mind like, yes, I nailed that?
Well, I guess the distinction of Albrecht versus Treon as removed and retained versus discovered or just removed, that little hair-splitting thing is really fun to do.
So what are your plans right now in the future?
Well, I'm graduating this year, so I'm going to go to college at Ohio University, and I've been accepted in 2 programs, piano performance and physics. So, not looking at law right now. Maybe I'll go to law school with one of those as my pre-law degree. I don't really know right now, but...
Piano and physics. They at least both start with a P, but that's very interesting. And you, what are some of your plans?
Well, I have 2 more years of high school, so I plan to think about it. Yeah, I'll think about it.
Well, good. As I said, I was really impressed by everything. I wish you, both of you, the best of luck, and thank you very much. We're going to, I think, bring on your witnesses now. So, thank you very much. Okay, so let me see. I think you played a doctor,
yes,
right?
Dr. Parker Reese.
And then you played the brother of the deceased.
Yes, I did.
And can I have your name and your grade?
Well, my name is Laura Markey, and I'm a freshman.
Wow, so you've got 3 years, so man, nothing like some preparation in this. And then you?
My name is Christian Thomas, and I am also a freshman.
So both of you, this is, wow, a trial by fire, and you came all the way up here to the finals. So what are you thinking? What were some of the highlights of today for you?
Well, it was just awesome to get here because our team's never done this before. We've only had the team for 6 years, and it was just really fun traveling together and doing the competition. We've had a tiring day, but have lots of fun.
Taylor?
What sticks out to me is all the fun that we've had over this process. It's been really great, and there's all the preparation. It's great, it's educational, and it's fun.
So was it hard to be interrogated by the other side? Did it make you sweat? Did it make you nervous?
Well, the first couple times my knees were shaky, but you get used to it, and there's a system. So you work on it, and if you work hard, you can work and excel.
Taylor?
I think I was nervous leading up to the cross, but once actually in the cross, I was actually not that nervous because I got gone over a lot of it before. So
I know you guys are freshmen, but is there any kind of proclivities you have? Are you thinking of law? What is kind of in the back of your mind? In 4 years, you're going to have to make a decision. 3 years, you're going to have to make a decision on what you're going to do with your life. So what are you kind of leaning toward right now?
I don't want to be an attorney. I want to be an orthodontist, which doesn't make any sense with this case, but that's just what I want to be.
That's cool.
And I really am thinking of either a career in the clergy, in the automotive industry, or possibly in law.
We can do them all.
Yeah, I could. I don't know how I would balance them all out.
Well, great. Thank you both very much. The best of luck to you both, and I think we're going to talk to the other witnesses now. So thank you. So you were the witnesses for the defense? Yes. So if I can get your name and your grades.
My name is Deanna Fettlinger, and I'm a senior.
My name is Shamir Bryce, and I'm also a senior.
And what school did you guys go to?
Archbishop Hoban High School in Akron, Ohio.
So how do you prepare for the medical mumbo-jumbo that you have to talk about?
You just, you keep reading, you look it up in the dictionary if you don't know. Don't be afraid that you don't know it, and you just keep on working hard. That's what I tell anybody.
I agree with that. You have to look through your statement, know every term that they used, and it really helps to go through with the trial.
So was there any part that you were like sweating in, or were you nervous, or did you feel like you hit a stride? We'll start with you.
Well, I'm always nervous going into these kind of competitions, and it's kind of difficult being last witness, but once you get up there, you kind of get more comfortable in the role, so it's good.
Now, there was, you were really going for a clarification. It seemed like one of the attorneys was really trying to needle you to say something that you weren't going to answer with a simple yes or no.
Right. There was nothing. I was supposed to have reviewed all the case material, and there was nothing in the case material that specifically said there was a transaction, and so I couldn't honestly say that there was a transaction, so I stayed to what the errata sheets had said.
And Dr. Brody, I got to say, I mean, I kept on looking at you, and I'm like thinking, there's no way you went to med school. You're not like a Doogie Howser or something like that. Your performance was spectacular. There was a moment where you took off your glasses and just wiped that. Was that truly doing that? Was that part of your actorial?
I couldn't see through them. I had to wipe them off. Of course, it's not an act.
It was. You were very, very convincing. So, what? You're both seniors.
Yeah.
What are some plans? What are you thinking about?
Not law. I am thinking.
Nobody wants to be an attorney after this.
I'm thinking about going into nursing.
Oh, well,
like nurse practitioner.
So this
close
is.
to a doctor.
Yeah. So this is very close to what you just did, kind of. So you've already have some background in legal, medical terminology, I guess.
I'm thinking about political science or history, but after 4 years, maybe law school.
There's a lot of attorneys that use political science and history as their background before they go for their JD. Well, watching this, and this is, I think, the third or fourth year that I've actually watched the whole trial. And a lot of times there's clear winners. I can't tell. I really can't tell.
It's really toss-up.
So is there, do you have like a gut feeling one way or the other?
I try not to rely on my gut. So sometimes I'm right, sometimes I'm wrong. So I don't have any. I think it's 50-50 right now.
I honestly don't know. I thought it was a very close competition, so it'll be interesting to see what the results are.
And you hear this, and it's different from different sides, but it's actually the act of participating, which is sometimes the best part of the competition. And I just think that both teams just did so extraordinarily well. And as an audience member, it's always just delightful and enjoyable to watch you guys just go at it. And it's amazing how much knowledge and how well you think on your feet. So, congratulations for getting to this level in the competition, and good luck with your future endeavors.
Thank you very much.
Thank you. Hello, can I have your name and your school and the grade that you're in?
I'm Lydia Richardson, and my team name is Olivia Davidson Washington, and I'm a freshman.
And my name is Jenny Wu. I'm also with Olivia Davidson Washington, and I am in 10th grade.
So the other team seems to have like years of advantage. There's a lot of freshmen and sophomore 10th graders coming into here. So what is it? Both teams did so well. What are your feelings right now?
It was a great competition, and I don't know. I honestly do not know.
Yeah, same here. It was such a tough competition, and it was so great. Yeah, both teams are awesome.
So, and what roles did you prepare for this?
Well, I'm Dr. Sydney Oxfordshire for the defense.
And I was Dr. Dana Brody, so yeah.
So what happens is as the teams are preparing for the state level, then you have two sides, right? So you have one team, so you never know until the day whether or not you're going to be the doctor. So you saw how the other doctors. Do you have any comments on their performance? And you can be nice.
Yeah, both doctors did a very, very good job.
Yeah, they certainly had a different approach than us. Like, their whole case was a bit different, but they did a great job with their case, too.
So now watching from the sidelines then, what are you thinking? Are there any highlights that you saw that happened?
I thought that the whole trial went very well. It would be really hard for me to pick one particular instance as the best.
Yeah, same here, but the cross-examinations, those are pretty intense.
Yeah, and I'm just thinking the subject matter. I mean, not only dealing with the legal issues of having to make a case and understand trial law and performance and all that kind of stuff, but now you have this whole medical ethics thing thrown in there. It's really really interesting. How much time did you take to prepare for this?
Well, as far as hours, I would not have enough fingers to count, but I've put a lot of hard work into this. It's a really hard job.
Yeah, we've been working on it forever, and especially since the trials were coming up, we were cramming every single week, and it was fun though. Yeah.
So I know it's a couple of years till graduation, but do you have any plans kind of right now that you're kind of leaning toward?
I like to do American Sign Language interpreting. Perhaps, yeah, I really like that.
So nothing legal that's popping out in your head?
Not as of right now.
And I like to write a lot. I like to write and act, so maybe I might write some books about law or something.
Wow. Well, there's a number of attorneys that have been very successful bestsellers. Well, both of you, thank you very much, and good luck. And hey, maybe we'll see you here next year and the year after, and then the year after for you. So thank you very much, and I think we're going to bring the timers up here now. So, in some ways, you were the most important position, keeping that time tick, tick, tick. Can I get your name, your school, and your grade level?
I am Maria Rizzo. I'm from Archbishop Hoban, and I am a senior.
I'm Alethea Robe, and I'm from the Olivia Davidson Washington Mock Trial Club, and I'm a freshman.
So, how many stopwatches were going on over there right now? How many were you using?
I was only using one at the time.
I was using two.
So you guys are competitors, and yet you're sitting side by side. Is there anything that you can do that we don't know, like stop your stopwatches or stuff like that? Is there any dirty kind of unsportsmanlike behavior?
I don't do any of that.
Yeah, you don't want to do that.
So you also have the advantage. I mean, you have to pay attention to the time, but you also you get to kind of watch from as curb or courtside spectators. What do you think? What are some highlights of the trial that you saw?
Well, I enjoyed all the closing and opening arguments. I thought both sides had really different views on the case point of view. I enjoyed, I'm biased because I love my team. I felt like their team did a really good job presenting their case as well, because I'm the part of the plaintiff side also. So I got to see my Parker Reese on their side, and I was listening in to see what their Parker Reese was trying to do, and I really enjoyed listening to that.
Well, I thought that both teams did a really good job. I really liked how both attorneys on either side did a good job in controlling the witnesses, and the witnesses started responding to that, to not trying to go on and on and on.
So now, tell me how because I was confused by the time. I didn't understand. Does each team or does each witness or the plaintiff and then the defense, I have to remember my legal terms, is it a cumulative amount of time? So if you only take 3 minutes in one argument, you can tack the rest of that on somewhere else. How does it work? How does the timing work?
Well, for the plaintiff side, they have 20 minutes for their direct, and the defense has 20 minutes for the direct cumulative. And then for their crosses, the defense, when they cross the plaintiff's witnesses, they have a cumulative of 18 minutes, and then vice versa.
So do they ever, during the competition, do people ever not use up all their time, or do they always use up all the time?
Well, in this case, they did not. And a lot of them, they don't try to go over, so they don't have, in case they want to get an extra thing on recross or redirect, they want to make sure there's enough leeway for that.
What are your future plans?
Well, as a senior, I'm looking into college for engineering and music at the University of Dayton or Akron.
Right now, the only thing that I'm interested in is art and stuff like that. So.
I think there's been one, maybe two students that have talked about law. So why'd you get involved with this if you're not interested actually in a career in law?
Well, actually, I'm a part of a big family, so I like to argue at particular points, and I like to present my own point of view. And my friend actually told me about mock trial my freshman year, so I was interested in that. And I was a lawyer up to now, as I was a witness this year. And I just enjoyed the entire aspect of like presenting one case and like hearing different points of views of that particular case.
Well, I've had older siblings doing this, so, I kind of got into that way. But I also thought it was a great opportunity to work on the presentational skills and just thinking through the law. So.
Well, best of luck to the both of you. Thank you very much, and good luck with your careers and your lives.
Thank you.
Thank you.
Okay, now we have the attorneys. And a witness. Okay, so you have to describe to me a little bit. Actually, why don't we start with this? Why don't we start with your name, your grade level, and which school you go to?
My name's Katie Capers. I go to Archbishop Hoban High School, and I'm a junior.
My name's Connor Morrissey.
I'm going to have you stand over. Actually, yeah. We'll scoot you in over here. Scoot you in over here.
I'm Connor Morrissey. I'm a senior, and I also go to Archbishop Hoban.
I go to Hoban too. I am Mark Frigo, and I'm a senior also.
So, what are your plans right now? Do you have plans after this?
Not immediately after this. For college, I'm looking into law with a minor in psychology, perhaps. I'm very interested in the law, but I am also musical, so I don't know. Not sure yet.
A lot of music. A lot of people want to go into music, but not a lot of people want to go into law. I think you're second or third. So what are your plans?
I'm thinking about going to law school. I'm not sure if I want to be an attorney or not, but, just play it by ear.
I'm not thinking about going into law. Maybe either business or journalism, probably.
So, what was your role here in the competition? What did you guys do?
Well, today we were audience members just cheering on our team, but Connor and I are the plaintiff's attorneys. So if our names would have been picked out of the hat, we would have been the attorneys today. And Mark is our witness. So.
Yeah, we had to wake up early this morning and didn't know who was going, so we all had to, get prepared and get ready. And it was kind of a flip of a coin whether we would go or whether the defense would go, and it was the defense. And we were, we'd like to have gone, but we're definitely happy that the defense went. We were very proud of their performance.
Absolutely.
What about what does the witness do?
In a general trial, I guess the main role of a witness is just to try to play the part as best as you can, and not seem too scripted, I guess.
So it's basically you knew this morning whether or not you would be up there.
Well, we came into the courthouse, and about 20 minutes before the pretrial motions would start, they took my folder and to put both schools' names and said, okay, here's plaintiff, and it wasn't us. So it was the other school, and that's what happened, but we're happy with how our other side did.
So what does it feel like to prepare? I mean, is it both kind of like you're disappointed, but you're also kind of relieved? Because that's a lot of pressure.
It is.
It is.
Yeah, it's kind of a double-edged sword. You're kind of also nervous, though, because you don't have any, decisions up there, and if they make a mistake or something like that, then you kind of get even more nervous. But, they didn't make any mistakes today, went up there and did their best, so we were really happy.
So do you have a particular highlight? Is there something you're like, oh, yeah, rock and roll?
I think so. Well, I think definitely the statements were, I think when Abby got up and did her opening statement, she, no notes, got up there, did it, definitely set a tone, and then kind of ended with Kristen's close. And I think that they both, no notes, got up there, controlled the judges, walked around, and I just thought that was really good for us.
Absolutely, and I was particularly proud of one of our attorneys, Kristen Brennan. She's been paying some great attention during this very long states competition, and one of the points that we got, somebody pounded on us yesterday in our trial, was that the Brotherton case, which is pretty crucial to this trial, was 20 years ago, and there's a more recent Ohio Supreme Court case that happened just 3 years ago, and so I was standing up here and watching Kristen, I was just like, yes, thank goodness she brought that up, so that was my shining moment for her. So.
Cool. Witness, what about you? Did you notice anything out of the ordinary?
Both of our witnesses did really well. I know they were pretty nervous, but they definitely pulled through.
Well, all three of you, best of luck with everything. I've been saying this. I think that it was I have no idea. There was not a clear winner, and I guess we're going to know here in a few minutes. Yep. So, thank you very much.
Thank you.
And I think we're going to talk to some of the coaches. Hello. So just give me your names and your who you guys are.
I'm Jeff Schobert, and we're advisors. I'm an advisor for Archbishop Hoban.
Mark Frazier, assistant advisor.
So what do you think?
Oh, I think it was a wonderful trial. I think both sides did very well, and that's exactly why they're both here right now. They're both playing well, and it's going to be. I'm glad I'm not judging.
What kind of advice, when you are the advisor, what kind of things are you telling them besides just knowing the case, knowing the in and outs of the case?
Down. Yeah, and be passionate.
Yeah. Try to think on your feet, slow down, be passionate. I mean, they have a limited amount of time. There's only so many things that they can actually cover in the time given, and just try to, connect with the court. Some of it is just trying to teach them to walk around that courtroom.
I've been really amazed at in talking with the students. A lot of them are not talking about going into law at all. Although they want to participate in this again.
Well, these kids are amazing. I mean, they do so many things, and this is just one thing. We only meet a couple days a week, and they're involved in all kinds of things thereafter. So, yeah, I think a lot of them that won't be their career, but they really love it.
Where'd you get your legal knowledge?
I went to Akron U, graduated there, and I've practiced in Akron for the last 25 years.
Ohio State University, and neither one of us knew that we were going to be lawyers when we were in high school or college either, so you never know.
Yeah, there you go. Okay, I think we're going to try, they may be getting ready, but I think we can squeeze in one more set of advisors here. If I can get your name and then who you represent.
Scott Robe. I'm the attorney advisor for Olivia Davidson, Washington.
Hi, Lonnie Welch, and I'm the teacher advisor for Olivia Davidson, Washington.
Okay, great. It got really quiet, but I was just told we have some more time, so we don't have to be super rushed.
I think that was because we were coming up to the microphone. So.
That's right. So what are your thoughts now after just watching this?
Well, I think what we aimed for from the beginning was just to excel at the material, and the kids prepared really hard, and we're just grateful to be able to be here. And it's the judge's decision, as in every case.
It's just really awesome to see the kids on both sides competing, and I know how much work our team and I'm sure the other team put into this, and I was telling Mr. Robe that he was crazy for how hard he was working the last 2 weeks, but I knew it would pay off when we got to state. So.
Well, yeah, I mean, this is the finals, and the other thing that I noticed in talking with the students is that they're really young. I mean, the other team is a lot of seniors. You have a lot of freshmen. So how do you get them, really geared up for something like this?
Well, really, they were a studious group, and we would sit around a conference table and talk about the case, and really they would generate a lot of their things. I'd also have to say that Sarah Welch was a senior this year and was really a good leader of the whole group, and they all prepared, worked really hard.
And I would just like to say that this is the 7th year that our team has, I think the judges are coming in now, so probably we should stop.
Great. We're about ready to hear the judges. I'd like to thank you all for watching, and we're going to be joining the judges down on the main floor directly.
Please be seated. Your judges have carefully deliberated upon the matter that's been presented to us. But before we announce the verdict or a judgment, we'd like to offer a few comments. And I'm going to start by just a general comment saying that I thought all of you performed very, very well. One of our goals, of course, is to encourage civility in the practice of law, and I thought each of you demonstrated that extremely well. You're also knowledgeable about your case, and I thought you, and I'm including all the witnesses in this as well, I thought you presented each of your cases very well. So I think, I hope you learned a lot about the legal process and particularly about trials, and we can be here in Ohio very proud of the work that you have done. So now I'm going to refer to, for comments on to President of the Bar Association, Roberto.
Thank you, Your Honor.
Let me start by saying that I really enjoyed sitting up here and watching this. My practice is criminal defense, and I've had an active courtroom and trial practice for 38 years. And what I was looking for before the competition started was to see whether or not there was a theme that wove through the trial. And both sides, I thought both teams did an excellent job of that. I wasn't quite sure where it was going at first, but as the trial went on, it became pretty obvious that a lot of thought had been put into what the issues were that you wanted to develop, and that the witnesses you selected, which was something else I was looking at, that time had been placed in that, and the preparation on both sides was very, very commendable. That was really excellent to watch. I also was involved in this program back when it started in 1983 and ran it in my hometown for about 12 or 13 years. And I have had the pleasure of running into some of the students that have competed in it in the courtroom since then. So I think that the people that played the roles of the attorneys would do very, very well in the court. The knowledge of the rules was excellent. The amount of time you spent was very, very apparent, and I thought you all did an excellent job with some of those rules that had reminded me when I was a young lawyer. I was in front of a judge, and he said, "Mr. Roberto, are you referring to rule so-and-so?" And I said, "Yes, Your Honor, I am." And he shook his head and said, "You know, there's no such rule. You shouldn't have said that." Taught me an invaluable lesson when I was young. Excellent job by everyone.
Well, I've been judging the finals for many years, and this was just perhaps the best I've ever seen. I mean, on both sides, it was so well conducted, and I don't have a whole lot to say. The party witnesses, that would be Tyler Henlacks and, of course, Dr. Brody, can be expected to be somewhat argumentative, and I thought you were appropriately so. The non-party witnesses, and especially experts, should probably dial back their argumentativeness somewhat, and you were both less argumentative than some witnesses I saw in earlier trials this week. But you were very good, and I just can't let this moment pass without singling out Ms. Welsh. I just thought your closing, you married the law to the emotions so beautifully. It was very well done.
Yeah, I'll start with the attorneys. I'm a district coordinator and a regional coordinator, and I don't judge there, but I do see the trials, and I've judged in some trials in the state competition this year, so I've seen this case a number of times, and the objections that were made and the discussion on the objections, it probably should be the best in the championship round. That's what you would hope would be the case, and true to form, I mean, I think the discussion, your ability to use the rules, to argue the rules in areas that were not, that really you could make arguments on both sides. I mean, I could single out a number of examples, but probably one example would be the argument at the end regarding the owning your body. Is that an appropriate matter for the ethicist to comment on? Is that a legal conclusion of law, or is that within the scope of her expertise? And I thought you both did a real good job of making arguments on that objection, and it seemed like that was the way it went all morning long. On the witnesses, the two-party witnesses, I agree with Judge Fain, were necessarily a little bit argumentative. This is a difficult case, I think, because it calls for the expert witnesses, even though Dr. Brody is a party, to be not real emotional, to have the dignity of the position, and I thought the expert witnesses all did a real good job of that. I mean, you really, it didn't call for you to get angry and get upset. It called for you to be somewhat dispassionate in how you responded. Did a real good job there were some, I thought the objections on invention of facts were probably as good in this trial as any that I've seen. And it's the same thing with the objections. The arguments both ways were really superb. The opening statements and the closing arguments, the opening statements did exactly on both sides what they should have done. You emphasized your claims, the evidence that you were going to present in support of those claims. You really emphasized how you saw the case differently than the other side. And in terms of providing a roadmap for the judges, it certainly did that. On the closings, I thought both closings were very good. There are always some things that I pick out that I really like, and I'm not going to go through all my notes, but on your closing, Ms. Welch, how you distinguished the case involving keeping the body parts when the autopsy is still being done and the body needs to be returned versus the facts in this case, I thought was really quite good. So I think both teams did a really superb job.
I certainly want to thank all the participants, but I would be remiss if I didn't thank the bailiffs for their outstanding job, and more specifically the parents for living through this experience. I think that it's about as difficult a process for the parents as it is for the students that participate, and thank you very much. For the students, I just have to repeat that you did an outstanding job. I had a little break in my judging. I used to judge for, I guess, for about 10 or 12 years, and then took a little bit of a break and was fortunate to come back and hear just an outstanding group of people. Your arguments, both in opening and laying the foundation for what we were about to hear, I thought were excellent. And then at the end, in the closings, to refer back to the opening statements, it's the old adage, first you tell them what you're going to tell them, you tell them, and then you tell them what you told them. And I think that that particular theme is beneficial to remember, not only if you happen to become attorneys and you would all fit very well in the legal profession, if that is what you want. I won't ask this group how many decided after this experience that you do not want to be attorneys. So I think this experience is going to go a long way in whatever you decide to accomplish in your lifetime, for this opportunity to stand up in front of people and think on your feet. And notwithstanding that there had to be nerves out there, none of you showed it. And I'm always impressed with that, because I would have been stammering and stuttering, and which is not good. So I just want to congratulate both teams and all the witnesses, because I think I happen to think the witnesses' jobs are the toughest. You got to remember all this stuff and then somehow figure out how to answer those cross-examination questions. So I congratulate you especially. Thank you.
I likewise want to congratulate everybody on an outstanding job. This was one of those trials where you walk off the bench and you really, in my case, don't know who won until you add up the totals. It's hard to know what to add to the comments, but I guess if I had to comment on one thing I really liked in this trial was the way both teams tapped into the emotional aspects of the case. I liked the plaintiff was focusing on who owns your body at the beginning, and I really liked the rebuttal in the closing of plaintiff where they said this is a simple case. They sold my client's brain. That's inexcusable and appalling, and it violated my client's rights. I thought that was powerful, and I like the way the defendant communicated the excitement of the discovery when Dr. Brody was testifying, and I like the fact that you emphasized throughout the case that there was much public good to come from this. I just thought both sides had strong emotional pull, and it made it persuasive and interesting to listen to. I agree with some of the comments that that witnesses can be too argumentative, but to me it felt authentic. I felt when Dr. Parker Reese was on the stand that she was getting exasperated, and I felt you as Brennan were getting frustrated, and again, it made the trial interesting to watch. So, performance aside, it made for excellent, theater, and I thought it was very well done. I want to compliment the defense on how it handled the the Dr. Brody receipt of money. I thought you handled that with great finesse. You acknowledged that he received some money personally. You didn't act embarrassed by it. You didn't try to explain it away. And I think because of that, they weren't able to damage you much with it. It was there, but it's hard to know what to make of it. I thought that was handled really, really well. And I will stop there, but I really, really enjoyed it.
Well, I'll echo the thanks that everybody's given, and I won't add too terribly much. This is the third year in a row I've done the final round, and I've seen before, and this is the toughest. I can say that easily. Like some other panelists have said, I didn't know who won when I walked out of the room until I added up the scores. These things sometimes get bogged down between two teams showing off who knows the rules better, and who wants to object more, and who wants to throw each other off the track, and they lose sight of the actual trial and the actual case and the human elements of it. And that's what I tend to look for in these types of things, is who's actually winning the case, not necessarily who knows all of these arcane rules better. Can you know them all much better than we do? And I don't envy Justice Cup, because I thought those objections could have went either way with just about all of them. So I think all of us are happy not to be sitting in his seat, certainly. I liked some of you guys, more so than I've seen two teams before, really listening to what each other's side was saying and playing off of each other. You have one side talking about the sale of a brain. They're taking the brain, and you guys saying is microscopic cells is what were involved here. So I liked that interchange back and forth, because this is a very human type case that knows no ideology, no left right, no conservative liberal, and I think all of us would have different opinions about this particular situation in real life. So I thought you did that real well. The defendants had a couple slippery witnesses, and I mean that in the best terms. I thought they were great witnesses, and then I thought the plaintiff side they were hammering away at the witnesses though, and did a good job of countering the slipperiness of the witnesses. So that was a great exchange back and forth on all sides there. The demeanor of Dr. Brody, I don't know if you did this on purpose or not, but when it came time to be interviewed by the other side, you were cleaning off your glasses, showing, I think, that you were going to be an unflappable witness, and you were very comfortable with what you were doing. So I don't know if that was intentional or not. I could see where it would be and maybe where it wouldn't be. Also, the gentleness of how you interviewed the family member on the defendant's side. You're up there, you're an attorney, and you're being firm and you're being direct, but offering your condolences and interviewing him in a way that I think other people would have lost sight of. I liked that human element of it an awful lot. And you both, again, you all sides here did a great job. It was a great back and forth to watch. I look forward to, for those of you who are still not seniors, seeing you guys in this competition again. And I think you'll have great success with whatever it is you pursue in the future. And if you are appreciative of civil liberties, then look me up sometime in the future after you get outside of law school, and we'll see what we can do for you. Thank you.
Before we get caught up in the excitement of presenting the awards, I just want to conclude by recognizing a few individuals for their service, or maybe groups, I guess. And first, I'd like to recognize and thank the panel that's judging here. Some are involved in the competition, others come in for the judging, but all are involved in the legal profession in the state of Ohio in a very big and important way, and so we thank them for their time and their expertise in this. Second, I'd like to thank the teachers who have enabled the students to be able to participate not only in the final round, but also throughout the whole competition. It takes somebody who's willing to do a little extra, in fact, maybe it's a lot extra, in order to give this opportunity to the students. So we thank the teachers who have been willing to do that extra bit to make a big difference. And I'd like to thank the volunteer legal advisors who lend their expertise and experience to the students and help them gain an understanding of the trial process and our legal system. And I'm sure this is information and guidance that's going to last a lifetime for the students, so we appreciate that. And as Representative Judge Slaby has indicated, the students, parents, and families, for all of your involvement and encouragement with your students and for your participation. And of course, to the students themselves who have stepped forward and are willing to participate. That really says something important about each and every one of them, that they're willing to do that and to also learn about the legal system. The Ohio Channel for not only broadcasting this live today, but also for recording it, to be able to make all of you today hear a star as they rebroadcast it on a schedule that they have, so the whole public can see what a wonderful performance that you've done. And now, Addie Natalie, coordinator of the mock trial program, I'm going to turn it over to you.
Thank you,
to ratchet up the excitement.
That's right. I want to, again, thank you so much for being here today. As Justice Cupp said, none of us would be here without you. So I first want to give everyone a great hand. Thank you. My name is Addie Natalie. I'm the Ohio High School Mock Trial Coordinator for the Ohio Center for Law-Related Education. And this center is fortunate enough to have sponsors who are represented here on our bench today who help make this program possible. The Supreme Court of Ohio, the Ohio State Bar Association, the Office of the Ohio Attorney General, and the ACLU Foundation of Ohio, as well as the Ohio State Bar Foundation. Without them, this program wouldn't be possible, so please help me in thanking our sponsors. I would at this time like to call Justice Cupp down to help me in announcing all of our team members. The students here today have prepared both plaintiff and defense sides, but our viewers have only seen each team present one of those sides. Many of the teams who participate in our programs are made up of more than just the 5 or 6 members that present that one side. So we would like to take a moment to thank the entire team and call them up. From Olivia, Davidson, Washington, Team Washington, I would like to please call up Advisor Lonnie Welch, who will help me in awarding the students.
Is this on? Yeah. Okay, I'd like to call our legal advisor, Scott Robe, who really is not an advisor. Scott is actually the guy who founded this team, and he invited me to come in and give him a hand. So I guess I'm called the teacher advisor, although in homeschool, I don't know if that's totally appropriate, but I'm the advisor. So Scott, would you please come on up and join me? And we're going to call, starting with the plaintiff, the opening attorney, Simeon Robe. Closing attorney, Sarah Welch. Witnesses for the plaintiff, Christian Thomas. And Laura Markey. Defense attorney, James Van Hook. And Lydia Richardson, a defense witness. And the other witness, Jenny Wu. And last but not least, our bailiff timekeeper, Alethea Robe.
Break up this team here.
From Archbishop Hoban High School Team Thomas, I'd like to invite forward Legal Advisor Jeff Schobert.
Well, thank you very much. I'd like to ask Mark Frazier, if I could, and Kevin Hillary, who have, Mark's a legal advisor with me, and Kevin Hillary runs the program at Archbishop Hoban and have been here the entire week, unlike my unavailability for the first day and a half. All right, I guess I'll start with our current team. Our first defense attorney, Abby Dankoff, please. And Kristen Brennan. Our two witnesses today, first Deanna Klutlinger. And Shamir Bryce. On our plaintiffs team that didn't compete this morning, first Connor Morrissey. Katie Capriz, our other defense attorney, or plaintiff's attorney, excuse me. Our witness from our plaintiff's team and today's timekeeper, Maria Rizzo. Yeah. And our final witness from our plaintiff's team, Mark Frago. We had a bailiff that couldn't make it due to a family emergency, Brianna Armand, who wasn't here with us today. I'll take that.
For you?
Okay.
Yeah, one for Brianna.
And one for the Maria. Break this team apart here.
Right here, Mr. Justice.
Oops, excuse me.
Thank you. And would you like to do the witness award? You're going to do everything for the witness, and then I'll follow up with the attorney.
All right, at this, should I use that so it can be picked up?
Oh, you have a mic.
Oh, I do. I'm already mic'd. Not used to being so vocal. At this time, I'd have the honor to present the Outstanding Witness Award. And as we already indicated, that's a very difficult choice, but the winner is Shamir Bryce, Archbishop Hoban. You were outstanding, no question about that. Too bad our camera's not.
There we go.
All right.
There we go.
Thank you very much.
Thank you. Keep up the good work.
Thank you very much.
Next, we're going to announce the Outstanding Attorney Award, but before we do that, I would like to give you a little background information. Last summer, the Ohio Center for Law-Related Education lost its visionary founder and dear friend, James E. Phillips. What began as a program that had 32 teams statewide 28 years ago, today boasts nearly 400 teams and 8 more interactive programs like this one. Ohio Mock Trial is the second largest program in the country, behind only California, and it's all because Jim Phillips thought big. Jim was a wonderful lawyer, a passionate advocate, and a really good man. We are proud to honor his life today with the James E. Phillips Award for the Outstanding Attorney at the Ohio Mock Trial State Championship Competition. If you could, please, Justice Cupp.
All right. Our outstanding attorney is Sarah Welch, Olivia, Davidson, Washington. I would like to invite the judging panel to come down, please, for the final two awards. They do on TV, tick tock, tick tock, tock.
Oh, goodness.
All right, the runner-up for the 2011 Ohio High School Mock Trial Competition is Olivia Davidson, Washington. I'm going to have you come all join us here, and we'll get a photograph. Get those wide-angle lenses out. Congratulations. One more, I guess. Keep up the good work.
To take a moment to introduce Jim Phillips' friend, Linda Shipp. He's going to say a few words.
Sorry I'm late. Lost my shoes. From the courthouse. How ironic is that yesterday we brought into debt. I'm not a litigator. I don't do trial work. It's like putting pins in my eyes. But I'm getting into it. And I just ran into it. I familiar letterhead. Well, anyways, I want to tell you a little bit about Jim. I'm sure you heard the history and how this happened. Okay. Every day I have a greater appreciation and admiration for Jim's accomplishments. Nearly a day goes by that I don't hear how well respected and a devoted advocate he was. He was in a league of his own. I feel confident that you will inherit and employ the exemplary ethics, passion, integrity, and dedication Jim had. It is with great honor and pride to present this award. Thank you for carrying on Jim's legacy.
All right, the winner is of the 2011 Ohio High School Mock Trial Competition, Archbishop Hoban. Yeah, you can hold that? You can put your hand on it.
There was one other woman that helped us with its illegal impartial, and
Yeah. All right, well, thank you everyone so much for joining us today and being here to congratulate these fantastic students who greatly appreciate it.
You've been watching the Ohio Channel's coverage of the Ohio High School Mock Trial Championship competition. Once again, congratulations to the winning team, Archbishop Hoban High School. They will head to the national championships in Phoenix, Arizona. To purchase copies of this program or to view it free online, visit us on the web at ohiochannel.org, where you can also view live and past video coverage of your Ohio government, including the Supreme Court of Ohio. From all of us here at the Ohio Channel, I'm Dan Schellenbarger, and thank you for watching.